Good afternoon, everyone. Let me take this opportunity to warmly welcome you to today's webinar on development projects, better regulations for better outcomes. We all know infrastructure is vital for development. Investments in large infrastructure projects such as railways, highways, seaports, airports, power plants are very important for economic growth and development. However, in Sri Lanka, around large infrastructure projects, we have had many discussions and debates about costs and benefits. And this is very important because although infrastructure investments are very important, unfortunately, when these take place in the context of poor governance and weak regulatory frameworks, these can become fertile ground for corruption and lead to costly infrastructure that is of poor quality and fail to meet the intended objectives. Therefore, we feel it is very important to understand the regulatory framework governing infrastructure projects in Sri Lanka, especially because there is so much debate and discussion about the benefits and costs of these projects. Regulatory framework plays an important role in ensuring whether these infrastructure projects actually deliver the expected benefits. So today, we have an eminent line of speakers with us who will share their research findings and also the research findings on procurement regulatory framework in Sri Lanka. And he will thereafter, Uween Jayasinha will present the research findings on the regulatory framework governing involuntary resettlement in Sri Lanka. Before I hand over to Senith, let me give you a little bit of information about the logistics for the day. So please feel free to post your questions in the chat box during the presentation as well. If you have any clarificatory questions, our speakers will take some time, if they can be answered with less time, to answer during the presentation itself. They'll pause for a moment and ask you for clarificatory questions. If any other question, we will take up at the open forum, which will be followed by the panel discussion moderated by our Executive Director, Dr. Nishan de Mel. And also to make, please note that the panel discussion, we will be having it in both English and Sinhala. So feel free to post questions in both languages. Now, without taking too much time, I would like to invite Senith Abeyanayake to share with us his research findings. Over to you, Senith.
Thank you, Subhashini. Good afternoon, everyone. Thank you so much for joining with us today. I'm Senith Abeyanayake, and I hope you are staying safe and well. So as Subhashini mentioned, I will be covering the area of public procurement when it comes to large infrastructure projects. So yes, so when it comes to public infrastructure projects and the public procurement process, this session will be structured where firstly we'll look at what public procurement is and why public procurement is important. And secondly, we will look at an overview of the current regulatory framework. And thirdly, we will look at some key gaps and weaknesses. In this session, we will be covering two, and then we will look at the key takeaways of this discussion. So what is public procurement and why it's important? So what is public procurement? Public procurement is where public institutions, so that could be governments, that could be state-owned enterprises, they purchase goods, services, and works for public use. So this could be, for example, ranging from a department in the government buying A4 papers or stationery for their year, all the way up to procuring buildings, bridges, roads. So it's a vast range, and given that the government is the single largest buyer in the Sri Lankan market, this process, the public procurement process, is something that is vital for the country. So when we talk about works, we are looking at constructions and large infrastructure projects, which is the topic that we are covering for these 2 days, will also be included in that. So that is why we are looking at public procurement today. So the public procurement process actually starts not only when we are not only focusing on the tendering and the contract award, but we are looking at from the start where we assess the needs. So where we look at whether something needs to be procured, and then how tendering happens, and then going into contract awards, and then how to manage the contract, and then finally up to the final payment. So the public procurement process covers that entire range. So it is from the start of a development project all the way up until the end. So public investments in infrastructure, so that is works contracts or works that are geared towards development, is vital, because if you look at the past decade, large infrastructure projects have been a key feature in the development agenda. And large infrastructure projects, of course, it utilizes a large amount of resources. Also, when you have a large infrastructure project, you expect broad impact. And of course, finally, it is something that is initiated to serve public interest. So we are looking at roads, highways, power plants, airports, seaports, water supply. So anything that has broad-based impact, which is large infrastructure for development. So when we look at large infrastructure projects, we have identified that there are several concerns that are consistently raised by the public, and we have distilled them into 4 considerations. Firstly, are the large infrastructure projects that Sri Lanka initiates, are they necessary? Are the costs reasonable? Are they built sustainably? And of course, when it comes to large infrastructure projects, we see a lot of them, especially the key infrastructure projects, being funded through foreign sources. So when it comes to loans, foreign loans, are the terms and conditions to fund these projects? What are they, and are they favorable to us? So when we try to answer these concerns, one of the key elements that pop out is the regulatory framework and the governance structure concerning large infrastructure projects. And if we are to expect optimal outcomes when we answer these through a project, then the governance structure is something that we need to definitely take into account and focus on. So the governance structure is something that is crucial for large infrastructure projects, and it is not only a local concern. Even internationally, the IMF has noticed that an average, when you talk about average countries, about 1/3 of their infrastructure spending is wasted due to inefficiencies, and half of these wastages or losses could be made up through better infrastructure governance. So what happens when you have poor governance for large infrastructure projects is that you, of course, have budgetary problems, and you have corruption, and also you have a mismatch of public costs and the spending of public costs to the benefits that we can potentially gain. So in assessing whether a large infrastructure project is meeting its goals or objectives, there are, of course, many metrics that could be used. But one such metric that is popular internationally and also locally, which is recognized through the guidelines and regulations, is the concept of value for money. So what we look at here fundamentally is whether we are generating value for the public money that is being spent for large infrastructure projects. And when we assess that, we look at several criteria. So here we are looking at 5 components. So you have efficiency, effectiveness, environmental concerns, equity, and economy. So when it comes to holistic assessment, all of these concerns must be looked at when you decide whether something generates value for money. We are conventionally used to maybe some of these recommendations or criteria, but when we look at a holistic approach for value for money, these considerations should be looked at all at the same time. So because the governance structure is important, and because regulations play an important role, we, through the study, look at the regulatory framework. So this session will focus on the procurement regulatory framework, and the sessions that are to be presented today and tomorrow, we look at other regulatory frameworks which concern the life cycle of a large infrastructure project. So providing an overview of the regulations surrounding large infrastructure projects, there are 3 sets of regulations that apply for large infrastructure in Sri Lanka. So if I will show the operation of these regulations through a scenario. So let's assume that the RDA wants to build a highway, and there are multiple ways in which they could go about it. Of course, the first is if they source through public procurement. So what we mean by sourcing through public procurement is where RDA recognizes, okay, this expressway or highway needs to be built at a certain location. It needs to be of a certain measurement, of a certain criteria, and they will then put it out and they will ask for bidders depending on the scenario. So this public procurement process is governed in Sri Lanka by the Procurement Guidelines and Manuals 2006. And these manuals are supplemented and amended by circulars issued by the Department of Finance of the Ministry of Finance, Department of Public Finance rather. And now so another consideration is that once an institution or a government department decides to go for public procurement, the next question is, of course, where does the funding come from? There are two broad options. Firstly is local funding. So if local funding is resorted to, of course, the Procurement Guidelines 2006 will continue to apply. But if there's a foreign funder who comes on board, either providing a foreign loan or a grant of a similar sort, then the procurement guidelines of that foreign funding agency will apply. So this is an exception recognized by the local procurement guidelines. So if a project is funded by foreign funding, and if the foreign funder has guidelines, then the national guidelines will differ and the foreign guidelines would operate. But of course, that's a public procurement process, but there are other options in which such large infrastructure projects can be procured. And one way is, of course, private investments through PPPs. So for that procedure, it's governed by the Guidelines on Government Tender Procedure Part 2, 1998. And one feature that we will be focusing on in this process is unsolicited proposals, because that has implications on the public procurement system as well. So that's a brief snapshot of the regulatory framework governing large infrastructure projects. So now moving on into the gaps and the weaknesses that we will be focusing on for this session. So we are focusing on two gaps. Firstly, poor visibility through limited procurement information. And secondly, frequent deviations from competitive bidding. So moving on into the first gap. So when you have a less visible public procurement process, so what we mean by less visible is when procurement information that should be in public domain is not in the public domain. So what happens when there's poor visibility is that the visibility results in two things. The first is that it encourages lethargy by the public officials who will conduct this process, because there's less scrutiny, their decisions aren't made public, the information is not out in the open. And secondly, of course, public oversight is a core component in monitoring, evaluating, and of course, keeping any process accountable. And when there's less information out in the open, that is less tools for the public to use in order to exercise public oversight. So what happens when these two things occur is that results in less answerability by the process itself, because now the process is less answerable to the public and what the objectives that stand for. And that would, of course, lead to more malpractices in the public procurement process. And that would have a direct impact on the value for money that is generated. There will be a low value for money if the process is less visible. So this is why we have identified this is why we think public procurement information being out in the public, hence visibility, is an important factor. So in order to understand what public procurement information is, we look at public procurement information and we categorize it based on international best practices. So this categorization is based on the OECD recommendations. So they classify public procurement information into three groups: public procurement system information, so that is information on the institutional frameworks and regulations. Secondly, specific procurement information, so that is procurement plans, tender notices, and contract awards of specific procurements. And of course, finally, the performance of the public procurement system, so that is benchmark monitoring and evaluating the performance of the entire system annually. So that would be through annual reports and such annual measures. So we have identified in public procurement information in Sri Lanka, we have identified a three limitation problem. So what we mean by three limitation problems is this. So if we take the set of information on public procurement, we have identified that three limitations or three barriers sequentially affect how this information is passed on to the public. So if you have public information or public procurement information, the first limitation are the limitations in requirements to disclose information. So if there aren't mandatory requirements, or if there are less requirements to disclose to the public, then that inherently limits the amount of information that the departments will disclose. But secondly, even when certain requirements are in the guidelines or the regulations, if the departments do not comply with such requirements, then once again, information is less, the access to information would be less. So in this situation, information is mandated, required to be published, but the departments don't comply with it. The final limitation, the limitation number 3, is even when the departments comply with and disclose information out to the public, if that information is not accessible, if the information cannot be accessed properly by the public, then that also is a limitation. So when these three limitations operate sequentially, what happens is that from the total set of information that could be out in the public, what the public actually gets is a very limited amount of information. So what we are doing through the next few slides is that we will be looking at how the three categories of information that we classified based on OECD requirements are disclosed with the operation of these three limitations. So looking at the first limitation, which is limitation of information disclosure requirements, Sri Lanka does not fare well in comparison to international best practices when it comes to information disclosure requirements. So when we talk about the three categories of information, the public procurement system information, so laws and institutions, they are mandated to be out in the public, and that disclosure is right now there. But when it comes to the performance of the public procurement system, there aren't regulations which mandate the disclosure of such information out to the public. So that limits that category of information. And when we look at the second category, when we come to specific procurements, some specific procurement information like contract awards and tender notices are required to be published. But however, information like procurement plans are not mandated to be published by the current regulations. So when we look at this through a holistic angle, we see that when we compare ourselves to our South Asian counterparts through a World Bank study, it was noted that our disclosure requirements do not fare well with the other regional countries. So one example to this would be regarding the information disclosed by the annual reports of the Ministry of Finance. Now, we stated before that the performance or the information relating to the performance of the public procurement system is not mandated to be disclosed. So what happens when something is not mandated to be disclosed is that we are giving the discretion over to the public authorities to publish information or not. And we see that discretion in operation through this graph. So the colors indicate the types of procurement performance or system information that has been disclosed by the annual reports of the Ministry of Finance across the years. And we see that there is a variation not only in color, so there's a variation in the types of information that has been disclosed, but in certain instances, even the amount of information when it comes to the types have been varied. So we would so the similar analogy example would be what the hotels and restaurants do when it comes to fruit salads, because we see in a lot of the cases, hotels and restaurants say that a fruit salad, they don't specify the kinds of fruits in the fruit salad, but they say that the fruit salad would have an assortment of seasonal fruits. And that gives the discretion to them to decide what fruits would be in the fruit salad. So transposing that analogy here, we see in, especially in years like 2011 and 2019, we don't even have a fruit salad in terms of information because there have been only one type of information disclosed. So this is the discretion that we feel should not be there when it comes to information disclosure, and how that discretion could lead to ad hoc disclosures of information. So moving on into the second category of the second limitation rather, would be limitations when it comes to compliance. So of course, when it comes to the compliance of publishing laws, we see that the departments have complied with in disclosing information regarding the public procurement system. And third category of information does not apply because there is no mandatory requirement anyway, so there is nothing to comply with. But when it comes to the second category of information, specific procurements, we see that even when certain specific procurement-related information are supposed to or mandated to be disclosed, compliance to such disclosure requirements is not up to par. And an example would be regarding contract awards. So this is the Ministry of Finance website on public procurement. So the public procurement guideline mandates or makes it mandatory for contract awards to be published. But if you look at the page, it has been last updated in 2015. So contract awards haven't been published regularly, but the page is still in operation because if you look at the tender notices have been regularly published even up to 2021. So this is where there is a variation in terms of compliance. So even though mandatory requirements are there, if they're not complied with, once again, the public is left with a low amount of information. So moving on into the final limitation, that would be limited accessibility of disclosed information. So here we see across the board that there is a problem when it comes to accessibility of information. So even though certain information are mandated, and even though those mandatory requirements are complied with, it's extremely hard to get public procurement information to be accessed by the public. So one glaring issue we see is that trilingual information is not published throughout. In many cases, especially when it comes to contract awards and tender information, we see more often it's either in English or in one or two languages. There is a variation there. So these are some of the examples as to why accessibility is is poor in terms of information. So if you look at the public procurement system, yes, the laws are published. Yes, the amendments are published, but there is no updated version of the procurement guidelines and manual 2006. And the problem with not having an updated unified version is that there are approximately 36 supplements which amend or which change the procurement guidelines, and also another 25 plus circulars that directly impact the public procurement system. And for one to understand the laws and regulations, the regulations that currently apply, one person has to go through these supplements and understand and impute them back into the document themselves, we feel is a severe hindrance to accessibility. And even when it comes to specific procurements, we see that one person has to browse through numerous websites to get individual procurement information, and there is no collated information, especially when it comes to tenders or contractual awards. And there is value to having collated information, and that is why private actors have stepped forward. So there is tenders.lk, which gives a subscription-based tender alert system. So there is value in collation, and that is a need by the public, but the public procurement system and the public institutions have not addressed that need. And finally, of course, when we look at the performance of the public procurement system, one has to go through various government documents in order to understand the performance of a particular year. So this could range from annual reports in the Ministry of Finance to the Auditor General to documents published by the Department of External Resources, once again making accessibility hard. So this is the three limitation problem in operation. So we have three limitations. And when we look at the limitations with respect to the three types of information, we see that increasingly the information is decreasing when it comes to the information being accessible to the public. So that is the first issue or gap that we have identified. So now we look at deviations from competitive bidding. So starting it off with why we look at deviations from competitive bidding. So deviations from competitive bidding, we feel is something that will directly impact value for money, because when there's less competition in the system, that will result in a lower number of bidders. There will be less choice that the institutions would have when they pick the winning bid. And when you have less choice, there's always a risk of having low quality or higher cost bids. So the range that we would get and the optimality when it comes to competition would be at risk, and that would have a direct impact on the value for money that we generate through these infrastructure projects. So The national procurement guidelines have identified this, and therefore in the objectives, it clearly states that a good procurement system and a good procurement process should be competitive, and all all parties should be in a level playing field. Um, so just looking in depth into how competitive bidding works in the national procurement guidelines, of course, there are deviations that are permitted from competition. It's not an absolute concept, but what we note throughout all these deviations is that the underlying principle or the underlying reasons for deviating is to ensure value for money, or even if there are deviations that do occur, they always try to protect value for money as well. So, for an example, if you take the types of competitive bidding, there are three types of competitive bidding in the national procurement guidelines. You have international competitive bidding, which is the most competitive form where bidders can come from any country. And you would have national competitive bidding, where bidders are restricted to locals or nationals. And you have restricted competitive bidding, where competition or the bids or the invitation to bid is sent to a list of identified potential bidders. Now, if you look at the deviation from international competitive bidding to national competitive bidding, the procurement guidelines say that the reason for so for an example, the prerequisite to going to national competitive bidding is when the prices in Sri Lanka are significantly below those in international markets. So even though there is a deviation, at least the regulations specify that the deviation should ensure better value for money, or at least better prices in this case. And even when we go into restricted competitive bidding, the justification to go for restricted competitive bidding is when there are inherently few sources or few able bidders out there who can bid for these projects. Therefore, the cost of advertising and inviting for bids would be too high. So underlying, we see the principle as to why such deviations are there. But of course, there's an exceptional procedure as well, where it looks at direct contracting. That is a scenario where the procurement of goods, services, or works are sourced from a single supplier. But when it comes to works, at least what the guidelines say, is that this measure should be resorted to in exceptional circumstances, and they have highlighted two. The first is that this could be done in a scenario where it's an existing contract. For an example, let's take a highway where 2/3 of the highway is built, and now we are looking at an extension to the highway. And in such an extension, you could potentially give that extension to be built by the contractor who built the first two portions of the highway itself, as long as the first two portions of that highway have undergone through a competitive bidding process to select that contractor. So even in that scenario, even where we give it to that contractor, the guidelines say that that contractor must be initially through a competitive process. And of course, the second requirement actually places a very high burden, where it says that if you are to resort to direct contracting, at least in theory, the prices that are there in that exceptional procedure through direct contracting should be such that there won't be any benefit that can be gained through competition, which is a very high standard to be placed. But of course, the caveat to all of this is that it's under the discretion of the Cabinet of Ministers. So therefore, the Cabinet of Ministers can decide if there are other considerations that could possibly merit direct contracting or even deviations from competitive bidding. So moving on into, yes, the public procurement system and unsolicited proposals. So the public procurement system, which, as I mentioned before, is governed by the National Procurement Guidelines, only allow for solicited proposals. So solicited proposals are where the procuring entity will put out the bids, or they will specify what the works would be, and they will call for a form of tender process. And then, as I highlighted before, such solicited proposals in the public procurement, in the National Procurement Guidelines, have competitive bidding as an underlying principle. Now, when we look at public-private partnerships, it's governed by the guidelines to the government tender procedure. And in such projects, both solicited proposals and unsolicited proposals are entertained. So solicited proposals, if entertained under PPPs, would go through the same process as I highlighted before. But unsolicited proposals are where a private entity will come forward and be like, okay, we think there should be a highway here and we can build it for you. But even in the guidelines to government tender procedure, where it highlights or it lays down the procedure for unsolicited proposals, it states that once an unsolicited proposal is received, you should ideally go back into competitive bidding. So even when you get an unsolicited proposal, theoretically, it should go to competitive bidding. However, once again, the discretion component comes into play, where the cabinet has a discretion to decide whether such circumstances merit unsolicited proposals to be entertained alone or not. So, but the problem here is that there seems to be a gap between theory and practice, where in certain instances, public-private partnership projects have gone through under public procurement guidelines, and also unsolicited proposals have been entertained for public procurement projects as well. So once again, weak regulations and this discretion component risk the generation of value for money through uncertainty in operation. So now just another component that comes into play is, of course, the foreign funding agencies guidelines, as I mentioned before. So now we have covered the first two types of regulations, national procurement guidelines and the guidelines for PPPs. But when we look at foreign guidelines, the loan agreements and the foreign procurement guidelines have a crucial component or have a crucial impact on this process. So as I mentioned before, if we go through local funding for a procurement process, then competitive bidding is underlying principle. But when it comes to foreign funding agency guidelines, there seems to be a difference, and there doesn't seem to be a uniform approach when it comes to the emphasis given to competitive bidding. So what is crucial here are loan agreement conditions and the procurement guidelines that are there. So when we talk about loan agreements, I think the general public discussion focuses a lot on the financial conditions, such as loan amounts, the interest rates, and the maturity periods. But we feel that there is also a crucial component, which are the non-financial conditions, and which also these non-financial conditions impact the procurement procedures as well. So we have classified two types of non-financial conditions here, where firstly, where there's a condition for untied loans. So untied loans here are loans that allow for a competitive bidding process. So there is no divergence from the emphasis there. But when it comes to tied loans, we see that tied loans have restricted forms of bidding, which can potentially deviate drastically from competitive bidding. So what do we mean by restricted bidding? So if I once again take a small scenario here, so assume there's a foreign funder who has come on board and provides a bilateral, so let's say it's a foreign country or an agency, they provide a bilateral loan to build a bridge. So the loan conditions and the procurement guidelines of this foreign agency can restrict bidding in the three ways in which we have identified. Firstly, where the contractor is pre-selected by the funder themselves, where there won't be any bidding process and the contractor is already decided through the loan agreements and in the pre-loan procedure. Secondly, is where bidding is restricted to a specific country, most often the lender's own country or the foreign funding agency's country. And this could also be a situation where even when there are bidders from outside the country, the purchasing requirements would be such that you must purchase a certain percentage of the goods and services from the foreign lender's country. So that is where bidding is restricted towards a particular country. And finally, you have unsolicited proposals, where a private company may propose to build this particular bridge before or after a loan is confirmed. So these are the types of restrictions that come about through foreign funding. So now let's look at how this has been applied in practice. So in practice, we see that Sri Lanka has frequently deviated from competitive bidding through especially bilateral loans. So here, this was a study done by Verité Research in 2020, where we analyzed the 50 highest value loans taken during 2005 to 2018. And out of these 50 loans for infrastructure projects, 15 out of 50 of these loans were by multilateral agencies, and all of those projects have been untied loans, which have gone through competitive bidding. So out of the remainder, which is 35 out of 50, which are bilateral loans, 28 out of those 35 bilateral loans have been restricted forms of bidding. So we could say that majority of the bilateral loans are restricted bidding. And out of the 28, 13 have been unsolicited proposals. And out of the 13 unsolicited proposals, 12 of those proposals have come through Chinese origin, through loans or funded projects funded through a Chinese agency or sort. So that is a snapshot of how this deviation has operated in practice and how this deviation from competitive bidding is something that is frequent. So the key takeaways from this gap is that, firstly, deviations from competitive bidding, of course, has a risk of increasing costs and also resulting in a lack of choice, and that erodes value for money. Secondly, when there are weak governance structures for unsolicited proposals and when there is high discretion, that reduces visibility and also increases malpractices, once again, which erodes value for money. And finally, when you have restricted bidding, that gives precedence to a particular type of bidder, which may potentially discourage qualified bidders from taking part in the process if there's a prolonged trend of having restricted bidding, and that will also erode value for money. So that brings us to a close to the second gap. So in conclusion, the four key implications of these two gaps are, firstly, that when a procurement process is less visible, it allows for malpractices. And secondly, when you have weak regulatory frameworks, that allows for discretion, in our case, the Cabinet of Ministers, which allows for ad hoc decision making. And thirdly, of course, when you have competitive bidding and we have deviations from competitive bidding, it compromises quality, cost, and sustainability. And finally, unsolicited proposals not being regulated can also lead to a lowering of value for money. So the key takeaways from this entire presentation would be where for large infrastructure projects in Sri Lanka, when you have less visible decision making coupled with weak regulations, that erodes value for money. So this brings me to a close on the session on public procurement. If you are interested in looking further into the public procurement system and also more gaps and weaknesses and also possible ways in public engagement, we have released a report in all 3 languages. In English, it's titled as Opportunities to Protect Public Interest in Public Infrastructure. It can be accessible through www.veriteresearch.org/publications. Thank you so much for joining in, and over to you, Nishan.
Thank you, Senith. That was a very interesting presentation. We are taking clarificatory questions at this stage. I know some people have asked substantive questions as well, and I think we'll deal with those with the panel towards the end. We have a few minutes before the next presentation comes online, during which we'll play you some videos and show you some other information. You can also take a break to get some water and etc. and join us. But you can also take the time to write down your questions, I think, while it's fresh in your mind. So I don't really want you to wait till the end, as I think Mr. Chandrajaratna has done. You could simply write down some questions that we can cover afterwards and take this time to reflect on the issues. But certainly, I think if there is any clarifications, we can do that immediately as well. So I will, I think, perhaps declare a recess right now. If there are clarificatory questions, we'll come back a little early and discuss them. But certainly, just stay with us. We'll be back. Uween will start his presentation at 2:50 in 5 minutes. But we have some stuff that you can watch as well while you wait, if you still remain in front of your computers. So I will switch off my video and wait for your questions, and we'll continue with the main presentations at 2:50.
Data is important because when we think about how we're governed, we want people to be really learning from the past in setting the course for the future. And data is the key ingredient, when properly understood, to make the best decisions for the future. Over the years, I've had to work with various data sets, but a key one has been on parliamentary data connected to the Mantri.lk parliamentary platform. In a nutshell, what it enables is for any person to find out what any MP has said on any issue in Parliament. It has been quite transformative in the way in which you can think through what actually happens in Parliament, and I'd encourage anyone who's interested to go and check out Mantri.lk. One example of parliamentary data being used in a transformational manner was when the then Minister of Higher Education went on to a political talk show and blamed the issues faced by universities on a particular students' union. However, the host had been to Mantri.lk and had got the information about what that particular minister had spoken of in Parliament. And then he turned around and said, but Minister, on such and such a day, you had mentioned that actually the issue was because there were managerial issues within the ministry. So isn't that the actual issue and not the students' union? For a moment, the minister's jaw dropped, because actually he was never used to being held to account for his utterances in Parliament. But it was actually a really good example of how data which is in the public domain, once it is processed through coding of parliamentary data and other things, can actually be transformative in how people are held to account. Many people ask, why should people seek data? I mean, first of all, I think we can all agree that this is just the way in which the data that is held by the state, which serves its people, can actually flow out. So using things like right to information is key. But I would also highlight one other really important point. You will realize that when you seek data, actually more and more information flows out. I can think of an example. When we were looking at Parliament and how data flows out of Parliament, before we knew it, people were saying, hang on a second, you're only looking at what happens in the main chamber of Parliament, but we do so much work in the committees of Parliament. We used that as an opportunity to say, but we don't have that information, make that public. Within 2 months, with the assistance of the Chief Government Whip and the Speaker of Parliament at the time in 2013 or 2014, all of that information flowed out. So seeking data actually has this cascading effect of actually getting more and more data as you seek and as you question more and more. So I would encourage people to not only use the information which is in the public domain, seek more data through RTI and other means that may be there, and you will see that actually a lot more flows out than just what you seek.
Let's get started with the second part of our presentation today, which is a look at involuntary resettlement. So as you know, involuntary resettlement is really about people who have to move where they live to make way for development projects such as roads or dams or what have you. And to make this presentation, we've invited Uween, who is one of the analysts at Verité Research, attorney at law, practicing in the courts as well, who has really become quite a specialist with regard to economics and regulatory law. So Uween Jayasinha, welcome to make the presentation. Over to you.
Thanks, Nishan. Just can I get a sense if everyone can hear me and see me?
Yes,
okay,
you're looking good. Yeah.
Okay. Hi, everybody, and good afternoon. So what I will be talking to you about today is essentially how Sri Lanka's involuntary resettlement framework works. And prior to that, I just want to tie this up to what Senith was talking about, basically the procurement framework, and say that the reason why we say that involuntary resettlement is very much part of the development agenda is that our own procurement laws require that the procuring entity actually has resolved all resettlement issues, all land acquisition issues, and all compensation issues prior to actually going ahead with the procurement. So in order for a procurement to go ahead, there has to be the involuntary resettlement process has to have been sort of resolved. And why we're talking about the subject of value for money, or how essentially we can make the most out of development projects, involuntary resettlement becomes extremely important for two reasons. Firstly, when you talk about involuntary resettlement, there are two serious costs involved in it. The first cost is that you're essentially transforming. The state has to undertake the burden of transporting or relocating an entire community to a different area. And this cost can actually can be sort of long drawn out, and it can involve social costs as well as financial costs. And the second cost that's involved is that it actually reduces the productivity of a particular community. So you have this resettled community, which this affected community that was productive citizens of the country, probably farmers who are probably involved in various occupations, having to be relocated. And this inherently reduces their productivity and their ability to actually contribute to the country. So by sort of not being able to, or sort of prolonging or having resettlement frameworks that are unsuccessful, or resettlement programs that are prolonged, you're essentially increasing these costs. You're increasing the possibility of communities not being productive. You're increasing the burden on the state. And we say that that actually has a major effect on how the overall value for money in terms of development projects can actually be transmitted. So going into the structure, let me just dive right in. My presentation will be broken down into 5 sections. So first of all, I will explain to you what exactly involuntary resettlement is and how it sort of differs from any other form of resettlement. Second, I will be explaining to you why involuntary resettlements are important in society, essentially saying that what does it serve to protect and what its purposes are. Third, I will tell you why participation or why the public's input is essential in involuntary resettlement processes, and why exactly having inclusive systems actually has more benefits than drawbacks. Fourthly, I will be just walking you through some of the best practices involved in involuntary resettlement, particularly in respect of how public participation can actually improve the quality of involuntary resettlement. And finally, I will go through the Sri Lanka's legal and policy framework and highlight some of the gaps and weaknesses that essentially have resulted in Sri Lanka having a weak involuntary resettlement framework that can potentially have severe consequences on value for money of our development agenda. So coming into what exactly is involuntary resettlement. So Sri Lanka's national involuntary resettlement policy defines involuntary resettlement as the unavoidable displacement of people without their consent, or in situations where consent for resettlement is only given because it's basically pointless to refuse it. So in the event that there is, say, a massive development project or a massive road going down your road, it wouldn't make sense for a person to actually object to it and say, look, I'm not going to give up my land, or I'm not going to move. So in that sense, we say that even if actually giving consent it becomes kind of fruitless. So in those situations where you are essentially forced to move, where there's a situation where you are sort of compelled or forced to leave your home or your native land, or give up your dependence on natural resources that you have used for your livelihoods and for your lifestyles, in those situations, we say that constitutes an involuntary resettlement, and particularly this occurs predominantly in sort of the circumstances where a development project is contemplated. Moving on to the second issue, the second aspect of my presentation is why exactly involuntary resettled people should be protected. So involuntary resettlement, or essentially the acquisition of private land for a development purpose, is essentially a trade-off. The trade-off is essentially entails that you relinquish the private rights or relinquish the rights and lands of certain people for the betterment of the greater society. So in a sort of a minuscule example of this would be essentially the acquisition of land for the purposes of developing a road, a power plant, or any kind of transportation means. In that situation, the society in large actually has benefit, whereas the actual private individuals or the families or the communities that actually are forced to resettle or give up their land would face a loss of homes, a loss of lands, loss of their security, and actually be thrown into the risk of poverty, and actually potentially lose their livelihoods and have severe lifestyle effects as well. So what we say is that there is essentially there's essentially a situation where there is this trade-off where private individuals sacrifice their private rights for the public good. And we say that because of this sacrifice, because of this trade-off, if you don't necessarily look after, if there aren't frameworks that actually ensure the well-being of people who have undergone this sacrifice for the benefit of public, we say that there are actually increased costs, and that actually takes away from the value for money of any development project, because we are essentially enriching one section of society while sort of risking or sort of throwing into risk another section or another community, which doesn't necessarily sort of create an equilibrium in terms of sort of fairness in society. So coming into why exactly involuntary resettlement, or rather public participation, is important in involuntary resettlement. So the World Bank, which is one of the sort of the leading financial institutions that actually fund a lot of development projects, has come up with the finding or has operates under this understanding that resettlement is only successful in the event that people positively respond to a resettlement. So essentially, the idea behind this is that resettlement is causes a family or a community severe hardships. It causes them to give up their homes. It causes them to give up their livelihoods, and essentially disrupts their entire life. So in those circumstances, if the actual community, which is essentially doing this for the purposes of giving the general public a greater advantage or greater benefit, if they are to face this, they ought to feel that their voices are heard, that they are involved, that they feel a sense of control, or that they feel responsible to what is exactly happening with their lives, and essentially that they have control over their fate. So in the event that you do provide this space for communities that are going to be resettled, to actually feel involved, to actually get involved, to actually voice their concerns, to voice their fears, they would actually be more responsive. And with additional response, with increased responsiveness, comes a better sort of management of expectations, sort of less tensions, and a more positive and a possibility of creating better outcomes in terms of resettlement. So we say that sort of getting the public involved or getting the stakeholders or the affected stakeholders involved becomes crucial when you're dealing with large groups, particularly in large groups that are going to be resettled for the purposes of a development project. So in line with best practices as well, best practices also talk about the idea that resettlement or involuntary resettlement sort of mandates the full participation of all affected communities as well as the general public in itself. So the idea is that essentially, if you have to look at the Asian Development Bank, for example, the Asian Development Bank sort of recognizes that civil societies as well as the general public can play a major role in implementing and sort of planning out involuntary resettlement programs. So, for example, civil society and public actors can be responsible for data collection, for sort of consultation and coordination, for facilitating discussions between all stakeholders and dialogues between stakeholders. Civil society actors can sort of be instrumental in disseminating information, and they also can be instrumental in when it comes to the actual implementation and sort of restoring the livelihoods and income of resettled communities. So we see that in the international space, or at least when it comes to best practices, the idea is that there is a lot of space for public participation, and there is especially a lot of room for the affected communities themselves to participate when it comes to involuntary resettlement, particularly because the more people are involved in the involuntary resettlement process, the more likely they are to feel in control and responsible, and that would garner a positive result. And as I explained before, with a positive result or a positive response to an involuntary resettlement, the chances are of the resettlement being successful sort of increases exponentially. So before I move on, I would just like to take a quick minute and ask if there's any clarificatory questions, anything that anyone needs to get any clarification on, or if there's anything at all that I would like for me to explain.
Uween, I think there are no questions at this time.
Okay.
So maybe, and your presentation's also quite short, I think, so maybe you can go.
Yeah, okay. So coming into Sri Lanka's legal and policy framework on involuntary resettlement, while there are many laws that contemplate the acquisition of land for the purposes of development, there are 4 instruments that I would like to highlight for the purposes of this presentation. Starting with the Land Acquisition Act. The Land Acquisition Act is essentially Sri Lanka's primary land, which is where formal process is set out for the purposes of acquiring the rights of private citizens. And under that, there are various regulations that have also been passed that sort of provide compensation and provide things like appeal systems to the general public. There's also the State Lands Recovery of Possession Act, which is a law that allows the state to evict people who are unlawfully settled on state lands. There's also the National Environmental Act, though strictly dealing with environment, actually sort of calls for more monitoring or a sort of a larger planning process when there's a situation of over 100 families being when it's contemplated that over 100 families are likely to be resettled. So while these three laws are actually some of the main laws that actually control or govern the involuntary resettlement in Sri Lanka, quite unfortunately, none of these laws contain some of the key principles such as public participation, full ensuring full compensation or providing of replacements lands, or actually even some of the basic aspects like the need to or the necessity to actually formulate a full and final resettlement action plan, which is crucial in ensuring a smooth resettlement. So in 2001, what happened was that the ADB, when the planning for the Southern Expressway was being done, the ADB recognized that Sri Lanka's laws did actually have these weaknesses and sort of encouraged Sri Lanka or sort of urged Sri Lanka to adopt the National Involuntary Resettlement Policy in 2001. So the NIRP, the National Involuntary Resettlement Policy, contains a comprehensive state policy on involuntary resettlement and also contains several policy principles, such as the need for the establishment of a resettlement action plan, sort of involving the entire community and sort of getting everyone to participate, the provision of resettlement lands, provision of compensation, and as well as giving entitlements to people who don't particularly own land but are necessarily dependent on lands which have now been taken for a development purpose. One of the key things of the NIRP was that one of the key policies of the policy principles of the NIRP was that it was actually supposed to be made a law or sort of incorporated into a law as opposed to merely being a policy document. But unfortunately, since 2001, this NIRP hasn't been included into Sri Lanka's laws, and therefore many of the policy principles recognized in the NIRP remain just principles and are not strictly legal obligations and therefore cannot be enforceable, which has created several problems as I will sort of go into a little bit more detail later on. So just to very quickly go through the land acquisition process in Sri Lanka. It starts off with the Ministry of Lands identifying a particular land and saying that this land is required for a public purpose. Then the divisional secretary calls for any person to object to the taking of that land or to provide submissions on why that land shouldn't be acquired. The Ministry of Lands will thereafter consider these objections and representations and either decide to obtain the land or not, but more often than not, they would be acquiring the land. After the acquisition of the land, a formal order is published and the land is surveyed and the land is preliminarily, there's a preliminary plans made of the land. And subsequently, again, the divisional secretary makes a public notice asking any person who has been adversely affected by the acquisition of the land to make claims for compensation. So that is essentially how the land acquisition process in Sri Lanka works. And then when it comes to the implementation of the NIRP, which I would like to remind you all again is only a policy document and not necessarily a law, it sort of starts with the planning and preparation of a resettlement action plan. The resettlement action plan goes through multiple rounds of review, then finally it is approved. And then with the assistance of divisional administration and the project implementing agencies, the resettlement action plan is implemented. Along with monitoring and evaluation happening simultaneously with the implementation. So moving on to the gaps and weaknesses of Sri Lanka's involuntary resettlement policy framework, we've identified 4 gaps and weaknesses, and it's important to understand that these gaps arise particularly because there are certain weaknesses in our own law and sort of predominantly due to the reason that the NIRP has not been converted into law and is therefore not enforceable. So like I said earlier, most of the core principles that are involved in involuntary resettlement, which are enshrined or which are encapsulated in the NIRP, do not form part of Sri Lanka's law. And this has created 2 serious problems. First is that it limits the opportunities for public participation severely. And second is that it reduces the access to information. So if I were to very quickly go through these four issues, the first is that we realize that when it comes to consulting the affected community and stakeholders, consultation occurs in a very ad hoc way. So like I said, none of our laws actually impose a legal obligation on how exactly communities should be consulted or communities should participate in the creation of a resettlement action plan or implementation plan. So what happens because of that is that developers and officials sort of create involuntary resettlement plans on their own or unilaterally without taking into consideration the opinions of the affected community, without speaking to community experts, without speaking to civil society organizations, or even without speaking to, or without even actually giving it sort of media coverage and sort of asking the public to contribute or asking the public to share their views. So this becomes problematic in, so it's not that consultation doesn't happen on all occasions. In many occasions, in certain occasions, they certainly have happened. But the thing is, at least from the purposes for during our research, what we found was that this doesn't happen uniformly. And the reason why we see that it doesn't happen uniformly is because there is no legal obligation to actually consult communities. And we say that this undermines the core principle of actually getting the public to participate in a involuntary resettlement program, because without consultation, people are not going to feel involved, and that undermines the entire process or undermines the ability for people to have a positive response to involuntary resettlement. The second issue is that in general, there is no space for public participation in Sri Lanka's involuntary resettlement laws or land acquisition laws, for example. Like I said, the Land Acquisition Act, the State Recovery, the Recovery of Possession Act, as well as the National Environmental Act, don't strictly sort of allow for public participation in the same way, say, the ADB or the World Bank allows. So I mentioned earlier how the ADB has specifically recognized that civil society actors or the general public can play a major role in things like data collection, in terms of income restoration of resettled communities, in sort of facilitating discussion and dialogues. So unfortunately, even though the best practices mandate that the civil society and the public can actually get involved to this extent and assist the government in resettlement, we don't really see our laws, or we don't really see our legal institutions actually having a space for this kind of public participation. And this becomes even more problematic in the situation where land is acquired on an urgent basis. One of the notorious problems in Sri Lanka's Land Acquisition Act is the fact that you can acquire land on an urgent basis, where there is no strict, like I mentioned earlier, there is no strict opportunity for the public to even object or to make representations and say, look, there is possibly a way of going about this without taking my land. There is no room for the public to sort of engage with the government, or sort of no room for the public to sort of come up with a better alternative. When the government deems the land is necessary on an urgent basis, then the only thing that the public can do, or the affected community can do, is just ask for compensation. So, for example, if your house today were to be acquired for an urgent reason, you could only claim compensation, but there's no way for you to object or say, look, there's a better alternative to this. So we see that the entire law is sort of silent on public participation, and actually has inbuilt provisions to further inhibit public participation. And we say that that again goes goes contrary to the core principle of involving people in a process of involuntary resettlement. The third issue that we've identified again is a problem that's not strictly common to, not strictly limited rather to involuntary resettlement, but a problem in most of Sri Lanka's institutions, is the fact that we don't disclose information. We don't disclose. We have a culture where information is sort of retained, and we feel that the sort of the state culture, state idea is that the disclosure of information would essentially mean more trouble. So because of that, even crucial documents such as resettlement action plans, resettlement implementation plans, community impact documents, or even timeframes, such documents and such information is not disclosed either to the affected community or to any other, or to the host community, or even the general public at large. So we say that that becomes severely problematic, because it creates a situation where the affected community and the public are sort of left in the dark about how exactly resettlement is going to be carried out. And this again undermines affected communities or the general public's sense of whether they are actually involved in the development process, whether they're actually involved in this. And that again creates situations like lack of transparency, lack of legitimacy, which can sort of undermine the meaningfulness of the entire project, sort of develop and sort of create more opposition, sort of create tension. And we say that that again is problematic for the simple reason that it undermines your core value, that you need to have public participation if you have a better, if you're expecting a better outcome for your development project. And the final issue is to deal with the grievance redressing mechanism. So if I were to simply very quickly talk about a grievance redressing mechanism, or an GRM, a GRM is essentially a mechanism where any person can sort of make representations on any concern or any problem that they have. So in terms of involuntary resettlement, a GRM is essential because you might have very, very serious issues on how to prove the title to your land, how to prove the level of compensation you're supposed to get, how to say, you were dependent on these particular lands or these particular resources, that your lifestyle is dependent on it. So there's a lot of concerns that an affected community would have in the event that when an involuntary resettlement is actually contemplated. But the problem, and especially when it comes to involuntary resettlement, the best practices are that there has to be some form of independent or at least a tiered GRM system where you can actually appeal. If you're not satisfied with the decision of a lower level, you should be able to appeal to a higher level. So that you have a sense of independence, so there is a sense of transparency, so you have a sense that your grievances are actually heard. But in Sri Lanka, under the Land Acquisition Act, we only have the system of LACs, that's the Land Acquisition and Resettlement Committees, which is a two-tiered system. The first system is the LACs, and the second tier is the super LACs. So how the LAC system works is that in the event that you actually, when a large-scale involuntary resettlement program is being contemplated, you could perhaps make your representations to the LAC, and if the LAC makes a decision and you're dissatisfied with it, you have the right to appeal to the super LAC. But the problem with the LAC system is that it is not applied uniformly to every single involuntary resettlement. It is unfortunately applied to only large-scale large-scale projects which are funded by foreign agencies. So on a say for a locally funded project or a relatively smaller scale project, which say would resettle about 30 or 40 families, chances are that the LAC system is not going to be imposed. So that effectively robs the people of the ability to address their grievances to an independent GRM system. Right. So what happens then, or rather the default position, is that, like I mentioned earlier, it's the divisional secretary who hears your objections and hears your claims for compensation. But what we have to understand is that the divisional secretary is merely an administrative unit. It is not a specialized unit in any way. The divisional secretary carries out multiple functions within its area, and for those reasons, it could have restraints in capacity. It may lack the specialized knowledge, particularly if you're dealing with land of a particular value or land which has particular users. The divisional secretary might not even have the specialized knowledge. And secondly, once the divisional secretary makes a decision, there is no appeal process. You are essentially stuck with that decision. So we say again that this sort of mechanism where you don't have a tiered mechanism where you essentially your GRM is basically the usual administrative processes as opposed to anything independent, again creates a sense that people can't really voice their concerns, or people are left in a way where their grievances aren't necessarily heard. And that again undermines the core value of how public participation, undermines the core value of public participation in involuntary resettlement programs. So finally, before I conclude, I would just like to say there's a misconception rather in Sri Lanka, how we say that if you are to have consultative processes, if you are to have participation, if you are to have more people included, it's going to result in delays, it's going to result in things becoming more problematic. But we say that it's actually the opposite. Because if we look at some of the findings of the World Bank, we look at some of the findings of the ADB, and as well as a lot of findings, a lot of literature that we have done in our research, is that when the public is involved, or when persons who are going to be displaced feel like they're willing participants in the involuntary resettlement process, or if they feel like they're involved, there are several benefits. For example, it's going to create legitimacy in the eyes. It's going to create better public cooperation. It can sort of create situations sort of with the public cooperation and with legitimacy, there is possibly going to be a sort of an increase or faster return to normalcy and productivity of these communities. And with that faster return to productivity comes the faster resumption of responsibility of their lives, which sort of takes away the burden of the state in having to look after these people. So we say that there are massive benefits. And in addition to that, with these benefits come the fact that it also can significantly reduce the fact that there can be delays. In the event that there's severe public opposition to involuntary resettlement, there can be severe delays that happen. We know in Sri Lanka that there are major legal challenges when it comes to land acquisition, some which go on for maybe 5-10 years. So we say that again creates delays, and that not only that, it aggravates tensions and creates a lot of animosity between stakeholders. And it can even result in situations there after you have actually planned and commenced a project, you may have to actually do adjustments because for whatever reason you might not be able to acquire land, or the public opposition is so harsh that the governments or the entity, the implementing agencies are sort of compelled to make adjustments in order to make the development plan function in a way that doesn't anger the public. So we say that when there is participation in involuntary resettlement, there is actually a lot of space for value for money for the value for money of development projects to improve. And we can actually you can get a greater insight to it if you look at our report, which is now being published on the Verité Research website. Thank you very much. Nishan,
thank you, Uween. Yes, thanks very much. So let me just kind of briefly remind maybe all of us of the two presentations we made and the main points that are made by the presenters. And I know there are many questions that have come up. Some are substantive, some are actually clarificatory. And what I would like to do is create some space for the presenters, and led by Subhashini, who's our sort of research director on this, to try and answer some of the questions before we get to the panel. Okay, we want to start the panel at 3:30, and so we have a little bit of time to answer some of the questions, I think, before we get there. So just to start us off, Senith, I think, looked at the issue of procurement, and that was the main part of his presentation. And he looked at, he started by talking about the information flow with regard to procurements and how that affected the value for money. So he highlighted three main things: the requirements to disclose information, compliance with those requirements, and even if it was supposedly disclosed, the ability to access the information. And he gave examples of how failure in all these three areas effectively undermine the possibility of doing better procurement. And countries like Sri Lanka lost out on that. He cited a very important study that that IMF had that said 1/3 of procurement costs are wasteful on large infrastructure projects. In trillions of rupees that are spent on procurement in Sri Lanka over the years, 1/3 is a very large sum of money. Our national debt could be substantially less. The crises that we are talking about could be prevented because it's not only that money, but it's also the interest on that money that then accrues in the form of debt. And the study also went on to say improving the governance processes can actually reduce this loss wastage by half. So it's not over optimistic. It doesn't imagine that everything can be fixed in terms of wrongdoing in procurement, but at least there's significant opportunities. And these studies are done typically by comparing countries that follow better practices versus others to say that very large sums of money could be saved by improving procurement. So after having talked about how procurement could be improved from a regulatory perspective, simply by paying attention to the information structure and access and compliance, he also talked about the bidding process that had very significant impacts in terms of what how Sri Lanka would benefit from procurement. He looked at bidding processes that effectively restricted bidding, going all the way from restricted bidding, tied bidding to unsolicited proposals, looking at how they had resulted in higher costs, how they result in malpractices that effectively added to the costs, and how they resulted in losing out on better contractors that effectively also add to the cost, but also reduce quality of outcomes, all resulting in a depletion in the value for money. I think Uween set out the basic issues of what we call NIRP, NIRP, he called it National Involuntary Resettlement Policy, which we have. Which is actually, even though it was put forward by ADB as a condition for lending to Sri Lanka, that it would be adopted as the law, because Sri Lanka has rather an archaic and a way of dealing with how you treat people when you want to resettle them for the purposes of development projects, that this has never been adopted into law, right? And the law we have unfortunately makes people victims in the development process. So when we think that development must serve humans, we have humans becoming victims of development, essentially, when the involuntary resettlement process isn't done in a decent way. And so he basically talked about, developing the process by which we actually resettle people, and not simply doing it in the way we currently have. And he gave some suggestions, right? So that you can actually improve it in 4 different ways. He said, well, that public participation in order to gain a reasonable approach to how you resettle them, compensation that's commensurate with the damage and the loss that you're causing to their lives and livelihoods, equitable treatment, because it is important that some people don't benefit out of development projects going past them and others do, and also efficiency, that this all leads to more efficient outcomes because you reduce conflict, delays, and probably the need to make changes. So it is also very costly. When you don't get this right, it's costly in terms of the projects themselves that can get delayed, that can get changed. It's costly in terms of human lives because people don't get compensated for the losses they make and can't rebuild their lives. And it's not just the economic outcomes, but also the human outcomes. That people feel unreasonably treated, and you are undermining the development as a human society by not fixing this process. So I think that's kind of the nutshell in terms of our presentations today. Why don't I just pass it on to maybe Subhashini? If you want to answer any questions now, but feel free to say you'd like to postpone the questions for later or take only a very few. And then we'll also give you guys maybe a 2-3 minute break and play another video, which hopefully the sound won't get interrupted, to come back to the panel discussion at 3:30. So Subhashini, over to you.
I think if I will let the 2 speakers decide whether they want to take any of the questions now or during the open forum. Senith and Uween, maybe you can make a call on it.
We can take any questions now in between as well. Maybe it's fine.
Yeah, so just a few clarificatory ones. I think Namal Ralpanava said LAC abolished by GOSL. They're applied on a case-by-case basis. So I think that was the point that Uween made as well. It's unequitable that government suddenly applies it when perhaps it goes through an area that they want to woo the constituency and not at other times, and that's not an appropriate way to handle that process. And in a way, it's a failure of the lending organizations to oblige the government to meet their own conditionalities, right? So there was a condition the government did sign up to, that it would pass it into law. But I think what we've seen is that development organizations, whether it's the World Bank or the ADB or Chinese banks, have not paid attention to the importance of entrenching that. So there are many conditions that development or lending organizations sometimes do impose, but perhaps these are a great condition for them to consider taking more seriously, because human lives are very, very significantly affected by ignoring this very important principle of how you resettle people. There was another question that says there's no legal obligation to prepare a RAP. I believe the RAPs are prepared due to FF guidelines or made public. Do you want to just respond to that?
Yes. Yeah. So the thing again with the RAPs is that it just falls again to the shortfall of the NIRP not being part of the law. Because if you were to look at some of the best practices, your resettlement action plan and your resettlement implementation plan are key documents, and if your law doesn't necessarily even provide for it, then again there is actually that becomes a bit of a problem, no? As you see that there is a failure in the system, in how things are managed and regulated in an equitable and sort of a fair way. And because there is no legal obligation, it's not even sort of disclosed also. So we do say that that is again one of the problems in Sri Lanka, where there is no legal obligation, and without that legal obligation, there is no further obligation to actually make sure that even the minimum standards are followed, our policy principles are followed, and that key documents that come about as a result of these policy documents, policy principles, are actually disclosed to the public. So yeah.
So the ad hocism problem that you mentioned, yeah, that undermines a sense of fairness, a sense of well-being that people have when they suffer the consequences of it, and increase the actually conflict and actions they take that then reduce the ability for the project to go ahead in a reasonable timeline, and cost all of society actually quite a lot as well. Let's guys move on. Senith, if there's a question you want to answer, feel free to jump in. But if I don't see you unmuting, I'll assume, yes, go ahead. Yeah.
Nishan, I think I will hold it on for the open forum because we are going to the break right now.
So we are going through we are going at a fast clip. We'll take a 3-minute break just to get the panel ready. But please stay with us because we will play you some other information that you'd like to watch and see. And we'll be back at 3:30 or as soon as the videos are over. But if you want to take a quick break to get yourself a glass of water, anything else, feel free to do that as well. We'll be back with you in a few minutes.
Do you have questions on Sri Lanka's economic outlook in 2021 and beyond? Have interest rates bottomed out, and when will they start rising again? Does Sri Lanka have a balance of payments crisis? And if so, what are the implications for the exchange rate? Does Sri Lanka have a path to manage external debt, and how feasible is this path? These are the types of questions that we address in the Verité Research macroeconomic briefing. This product is a structured macroeconomic analysis that is derived through a multidisciplinary approach. The briefing provides analytical foresight on key economic variables and the overall economic picture of the country. Our product is distinct from others since it is data-driven, independent, and takes into account political dynamics in the country. The product is available as a one-off briefing or as an annual subscription that includes 3 full briefings and an update each month. This product would be beneficial to all Sri Lankan firms navigating the challenging and volatile operating environment in 2021. It would be particularly beneficial for firms in the financial market industry, the boards of directors and corporate managements of those firms. It would also be useful for foreign investors and non-profit organizations looking to make an impact in Sri Lanka.
Hello and welcome everyone. Thank you for joining today's session. We'll be beginning our panel discussion, a look into public procurement and involuntary resettlement, and we'll be having our open forum afterwards as well. So for the panel, it will be moderated by Nishan de Mel. Nishan de Mel is the Executive Director at Verité Research. He's an economist with extensive academic, policy, and private sector experience. Nishan taught and researched economics at Oxford and Harvard University. In the 1990s, he sat on multiple presidential task forces in Sri Lanka, playing an instrumental role in designing national policies on health sector reform, social security, tobacco, and alcohol. He also served as the executive director for the International Center of Ethnic Studies and the Sri Lanka Foundation Institute. Nishan completed his undergraduate studies at Harvard University and his graduate studies in Oxford University, where he was a Chevening Scholar. Welcome, Nishan. And in terms of introducing the 3 panelists that we have for today, beginning first with Iromi Perera. Iromi is a Colombo-based researcher, activist. She works on land rights and spatial justice with a focus on development and disposition in post-war Sri Lanka. At present, she is a co-investigator and leading the research work in Colombo for 2 multi-country research projects funded by UKRI's Economic and Social Research Council. studying human infrastructure interactions in the context of urban crisis and urban change. She's also an Asia consultant for the Bank Information Center in Washington, D.C., and monitors MDB financing in Asian region. Welcome, Iromi, for today's discussion. And let me welcome our second panelist for the day, Priyankara Costa. Priyankara is a training coordinator and animation officer at the National Fisheries Solidarity Movement, NAFSO. He is currently involved in conducting training programs for local communities on leadership development, community mobilization, and citizen engagement with government officials and institutions in civil society organizations as well. He's involved in a number of projects related to issues of land ownership and assisting displaced fishing and farming communities with large development projects in the south and the north part of the country. And finally, our third panelist for today is Shriyani Vijayasundara. Shriyani Vijayasundara is a senior researcher for capacity building and outreach and of the monitoring unit and the head of the local government program at the Center for Policy and Alternatives, CPA. She's a specialist in monitoring and evaluation, women's political rights, and local and regional planning, and a geographer. She is also a participatory budget analyzer at the local government level. Welcome, Shriyani and Priyankara, to the panel. And over to you, Nishan.
Thank you. So just a quick note, we typically like to do Verité events in all the languages we can do. And we try to focus on 3 Sri Lankan languages. Today, we were not quite capable of pulling the presentations off in more than one language, so we kind of did it in English. Our panelists are really kind of going to help us out there. So we've invited Priyankara and Shriyani to please present in Sinhala, and Iromi will present in English. And we really want to widen the audience of those who can engage with the content here. Now, I want you all to feel free to ask questions in Tamil, and hopefully we can answer in another language, but we'll have someone to try and understand the questions if you do that. But just to say, we are really grateful for the panelists who have joined us today. They're a great panel, enormously well-versed in the different issues that were brought out in the different presentations. Let me just start by asking each of them, maybe because they've come with so much experience, we don't want them simply only to respond to the content we put, but actually, widen the scope of the discussion by sharing some of their own ideas and observations and connecting it to the content. Iromi, can I start with you and invite you maybe for 5 minutes or so to perhaps share with us your thoughts on these issues. Over to you.
Thanks, Nishan. Thank you for having me, and congratulations on the report. I've taken a look at it, and it's very comprehensive, and definitely it's a very useful document for us to have. So in the next 5 minutes, I just want to maybe make 3 remarks regarding involuntary resettlement. One is that we have advocated for a long time for the NIRP to be legislated with no success, but we should definitely keep pushing for it. And as we've experienced over the years, and as this report sets out, it's one of the strongest policies available to communities who are getting displaced. The NIRP was created to address the gaps in the Land Acquisition Act, and it includes so many aspects that would have a qualitative difference in the lives of the affected communities. And this includes compensation and support for non-title holders and those engaged in informal livelihoods, compensation that is calculated at replacement cost and not at market value. And the other, for me at least, the key importance of the NIRP is that when people are involuntarily relocated for development projects, they aren't always living on private land. You have people living on state land also on various sorts of permits, and sometimes without any sort of permit or formal land document. And this means that in most cases, they have little to no rights and are considered to be squatters or illegal dwellers, even though majority have been living there for generations. So the fact that the NIRP makes space for all sorts of land occupation and tenure is very important. However, it has been 15 years since the NIRP was drafted. And while we do need it for it to be legislated, it has to be done after updating it to bring it in line with international standards. For example, aspects like child rights and rights of persons with disabilities has to be integrated or at least mainstreamed into the entire policy and not seen as a checkbox under a section on vulnerabilities. There also has to be more data disaggregation in the initial analysis done on affected communities so that we can see differentiated impacts on various groups and learn from those experiences. We need better and more robust social and environment impact assessments that should be made compulsory, not just to see how relocating communities can be justified, but also to ensure that they're not paying a huge price for development. And these assessments should take into account not just the value of the loss of the house or the land, or at least the physical structure, but it should also look at the impact of the impact on natural resources, as well as the loss of intangibles, things like community ties, kinship networks, the loss of livelihoods, and ensure that whatever entitlements that people receive take all this into consideration. Finally, I think one of the key aspects of the NIRP that has to be updated is the GRM, or the grievance redress mechanism, where there has to be systems where, for example, anonymous complaints can be made without a fear of retaliation. And there are many other such standards that need to be updated in the NIRP. The second point that I want to make is regarding the capacity of the state sector in implementing these infrastructure projects, particularly when there is involuntary resettlement involved. 2 years ago, Priyankara and I were part of a People's Land Commission that was initiated by the People's Alliance for Right to Land in Sri Lanka. And the two of us, along with several other commissioners, traveled all over the country for many months, meeting with various people and communities who had been displaced from their land due to several reasons, and some of them included infrastructure projects. And something that kept coming up wherever we went was the clear lack of empathy and the inefficiency the affected communities faced whenever they had to deal with the state, whether it was the RDA or the UDA or even their own DS office. So, it's one thing for the World Bank or the ADB to build the capacity of these institutions to carry out their safeguards or put together a resettlement action plan. But if the people carrying out these projects don't particularly care about the plight of affected communities, or don't have the capacity to understand the impact of dispossession can have on people, or even take the time to understand why people resist relocation, there will never be an equitable development. Even something as basic as not giving people adequate information, not speaking to them politely, sending them from pillar to post to get something done, or requiring people to make multiple visits to government officers on a weekday, which means that people have to take time off their work. And these things hugely impact people who are already undergoing the stress of being dispossessed. And I think the third and final point I want to make is regarding what is considered as a public purpose. In the last 10 years alone, so much of land has been acquired for public purpose, and they have been for various development and infrastructure projects. And when you look at what these actual projects are, you can see that there is a very broad definition of public purpose that is used. And it also includes things like high-end luxury condominiums, shopping complexes, road widening for 6-lane highways in areas that even a 2-lane lane would do. And I think Priyankara and I were there for that particular one where they were trying to expand this area in Hambantota. And even though the Land Acquisition Act doesn't specifically state that the public purpose has to be disclosed, judicial pronouncements have held that non-disclosure of the public purpose to be fatal to the acquisition. The non-disclosure of the public purpose makes it difficult for affected communities to make a fully informed decision regarding the acquisition process, whether to challenge it or even challenge it at a later time when the final land use is under scrutiny. So to end, what I want to say is, we can look at things from, value for money and all those things, but dispossession can have generational impacts on communities if their relocation process is not done in a meaningful and a proper way. And the loss of their home and the land that they have invested in, the loss of livelihood and community and their entire way of life, it's a massive upheaval. And in Sri Lanka, we see that, just going on for years and years and years. The words involuntary resettlement alone addresses that the act is not a fair one or a just one to begin with. So we need to ensure that communities are not left worse off in the name of development. So I'll leave it there for now, Nishan, and maybe we can pick up later with the questions.
ප්‍රියංකර මම දැනගත්තේ නෑ ඔය ඉරෝමිත් එක්ක ගොඩක් වැඩ කරලා තියෙනවා කියලා අහන්න සතුටුයි. ප්‍රියංකරගේ ආයතනයත් මේ NAFSO කියන ආයතනය මම හිතන්නේ රටේ ඉතාමත් වැදගත් පිළිගත් ආයතනයක්. සමාජය පිළිබඳ වැඩ කරන ආයතන හැටියට මම හිතන්නේ ගොඩක් ප්‍රසිද්ධයි. ඉතින් ප්‍රියංකර අපිත් එක්ක එකතු වීම ගැන අපි බොහොම සතුටු වෙනවා ප්‍රියංකර. බොහොම ස්තුතියි. විනාඩි 5ක් තියෙනවා ප්‍රියංකරගේ අදහස් ඉදිරිපත් කරන්න. ප්‍රියංකර Costa everybody. Go ahead ප්‍රියංකර.
දැන් මම හිතන්නේ මම පළමුවටම ස්තුතිවන්ත වෙනවා මට මේ අවස්ථාව ලබා දීම සම්බන්ධව. මම හොඳට ඇහෙනවද? ඇහෙනවා right okay. ස්තුතිවන්ත වෙනවා. අනිත් එක තමයි අපි මේ වාර්තාව පිළිබඳව ඇත්තටම දැන් ඉරෝමි බොහෝ දේවල් සඳහන් කරා. ඇත්තටම වාර්තාවේ තියෙන කාරණාවල් සම්බන්ධව මම හිතන්නේ අපි කියපු අපි සාකච්ඡා කරපු බොහෝ දේවල් මේකේ අන්තර්ගත වෙලා තියෙනවා. මේක ඉතාම වැදගත් වෙයි මම හිතන්නේ අපිට අනාගතයේදී ජනතාව බලගැන්වීමේ කාර්යය සඳහා මොබිලයිස් කරන්න මේකේ අම්මාකාරයක පොඩි පිටුවහලක් වෙයි කියන එක මම විශ්වාස කරනවා. ඒ විශ්වාසයේ මත ඉඳගෙන තමයි මම අද මේ දවසේ ඔබත් එක්ක මේ කතිකාව සිදු කරන්නට බලාපොරොත්තු වෙන්නේ. මම මේක ආරම්භ කරන්න කැමතියි ඇත්තටම පොඩි මේ චූරි අත්දැකීමකින් මම පටන් ගන්න කැමතියි. මම දවසක් යනවා ඇත්තටම මේ යාපනයේ තියෙනවා මේ IDP camps අනාථ කඳවුරු තියෙනවා. දැනටත් තියෙනවා ඇත්තටම. දැනටත් තියෙනවා. ඉතින් කඳවුරකට ගියාම වයසක අම්මා කෙනෙක්ව මට මුණ ගැහෙනවා. මේ වයසක අම්මා කියනවා පුතේ මට මැරෙන්න ඉස්සර වෙලා මගේ ඉඩමේ ගිහිල්ලා පය ගහන්න ඕන. මට මැරෙන්න ඉස්සෙල්ලා මගේ ඉඩමේ ගිහිල්ලා පය ගහන්න ඕන. එච්චරයි මට ඕනේ කිව්වා. ඊට පස්සේ මං හැයි මොකද උනේ? මොකද වෙලා තියෙන්නේ? එතකොට මේ 1990 ඉඳලා අවතැන් වෙලා මේ කඳවුරේ ඉන්නවා. මෙයාට දැන් යන්න ඕන තමුන්ගේ ඉඩමට. ඒ කියන්නේ අම්මා කියනවා මේ තාත්තා මැරුණේ හූල්ලලා එයාට ය아가න්න බැරුව ගියා ඉඩමට. ඒතකොට මටත් එහෙමම වෙයිද? කියන්න සතුටුයි ඇත්තටම 2015 2016 වෙනකොට ඒ අම්මට අවස්ථාව ලැබුණා එයාගේ ඉඩමට ගිහිල්ලා රැකලා පදිංචි වෙන්න. මම ගියා එතනට. ඇය හිටියේ පුදුමාකාර සතුටකින්. එතකොට එයාට එතන පදිංචි වෙලා ඒක ගේ හදාගෙන තිබුණා. ඒතර මම මේ කියන්න හදන්නේ ඇත්තට මේ සිදුණු ක්‍රියාවලිය හොඳට සිදුණා කියලා නෙමෙයි ඇත්තටම කියන්න හදන්නේ. නමුත් එයාට ඒ තිබුණු ආශාව ඉෂ්ට වෙන්න අවස්ථාවක් උදා වුණා කියන එක තමයි මට කියන්න ඕන තිබුණේ. කියන්නේ ජීවිතයේ ඉඩම කියන්නේ ඇත්තටම බොහෝ විට මේ සාමාන්‍ය ජනතාවගේ ජීවිතය. ඒතර මේ ජීවිතය තමයි යාලට ඇත්තටම නැති වෙන්නේ කියන අදහස තමයි පළමුවම තියෙන්නේ. ඒ නිසා මම පළමුවම කියන්න කැමතියි මේ ඉඩම හා බැඳුණු ඕනම කාර්යයක් කරද්දී හරිම සංවේදී කාර්යයක් කියලා තමයි මම සලකන්නේ. මොකද මම මේ ලංකාව පුරාම ගමන් කරද්දී මම හිතන්නේ ඉරෝමිත් එක පැහැදිලි කරා අපි ලෑන්ඩ් කමිෂන් එකේ වැඩේට යනකොට ලංකාව පුරාම ඊට අමතරව මම දිස්ත්‍රික්ක 15ක ඇත්තටම මේ වැඩසටහන් ක්‍රියාත්මක කරගෙන යන පුද්ගලයෙක් විදිහට මේ ලංකාව පුරාම ගමන් කරද්දී අපි දැකපු එක දෙයක් තමයි මේ ඉඩම කියන්නේ ඇත්තටම මිනිස්සුන්ගේ ජීවිතය කියන එක. එතකොට මේක තමයි මට පළමුවෙන්ම කියන්න තියෙන පළවෙනිම කාරණාව. අපි කුමන දෙයක් ක්‍රියාත්මක කරන්න ගියත් නැවත පදිංචි කිරීම කියන කාරණාවේදී අපි ගොඩාක් සැලකිලිමත් වෙන්න ඕනේ අතන මේ ඉඩම කියන එක ජීවිතය කියන එක බව අමතක කරන්න එපා කියන එක. ඒතර අනිත් කාරණාව තමයි දෙවෙනි කාරණාව මට මතු කරන්න ඕන වෙන්නේ ඇත්තටම අපි බොහෝ වෙලාවල් වලට මේ නැවත පදිංචි කිරීමේ ක්‍රියාවලියේදී දැකපු කාරණාවල් ගණනාවක් තියෙනවා. මම හිතන්නේ ඉස්සරහටත් අපි කතා කරන්න පුළුවන් ඒ සම්බන්ධව. නමුත් මම මතු කරන්න කැමතියි ඇත්තටම ජනතාව මොනවද දන්නේ? ගොඩක් අය අහන ජනතාව මොනවද දන්නේ? මොකද ගොඩාක් ජනතාව හිතන් ඉන්නවා නිලධාරීන් තමයි දන්නේ. ඒත් අනිත් පැත්තෙන් හිතනවා අපි මොකුත් දන්නේ නැතුව ගියාම අපිට මේ මහත්තුරු කියන දේ තමයි අපිට අහගෙන ඉන්න වෙලා තියෙන්නේ. මේ බොහොම පහළ ඉන්න ආන්තික ජන කොටස් තමුන්ගේ හඬින් කියන එක දෙයක් තමයි අපි ඇත්තටම දන්නේ නැහැ නේ මහත්තයෝ. අපි මේවා ගැන අවබෝධයක් නැහැ. ඉතින් මේ අවබෝධයක් තියෙන මහත්තුරු මේක අපිට ඇවිල්ලා හරියට දැනුවත් කරන්න ඕන කියන එක. ඒ ප්‍රශ්නේ තියෙන්නේ මේ අවබෝධය අපි සියලු දෙනාටම තියනවාද කියන එක. කියන්නේ නැවත අපි යම් ආකාරයක සංවර්ධන ව්‍යාපෘතියක් ආරම්භ කරන්න යනකොට ඒ සංවර්ධන ව්‍යාපෘතිය පිළිබඳව නිසි අවබෝධයක් අපිට තියෙනවාද? මේක පහළට ගලාගෙන යෑමේ යාන්ත්‍රණය ඇත්තටම ක්‍රියාත්මක වෙනවද? තියෙනවා. බොහෝ දේවල් දැන් අර අපේ ඉස්සර පැහැදිලි කරපු සහෝදරවරු දෙන්නම එයාලගේ ප්‍රසන්ටේෂන් දෙකේදී පැහැදිලි කරා මේ process එක. ඒ ක්‍රියාවලිය පැහැදිලි කරා. මෙන්න මෙහෙම තමයි ක්‍රියාවලිය තියෙන්නේ. හැබැයි මේක භාවිතා වෙනවද? මේ භාවිතයේදී කොයි විදිහටද සිදු වෙන්නේ කියන මේ අත්දැකීම් හරියට වැදගත් වෙනවා අපිට මේ සාකච්ඡාව ඉස්සරහට තවත් උතුරටත් ගොඩ නගන්න. ඒතරේ දෙවෙනි කාරණාව මට ඇත්තටම උත්සාහ කරන්නේ මම කියන්නේ අපි දැනුවත්ද? දැනුවත් විය යුතු පිරිස කවුද? දැනුවත් විය යුතු ආකාරය මොකක්ද කියන එක පිළිබඳව අපිට මීට වඩා සැලකිලිමත් වෙන්න වෙනවා. තුන්වෙනි කාරණාව ඇත්තටම මතු කරන්න මට උවමනාව තියෙන්නේ මේ ගමනේදී ගොඩාක් කලාවල් වලට අපි මුණ ගැහුණු තැන් තියෙනවා ගණනාවක්. මම අද දවසේ ඔයාලත් එක්ක මේ අත්දැකීම් බෙදා ගන්න කැමති විශේෂයෙන්ම ත්‍රිකුණාමලය වගේ ගත්තොත් ත්‍රිකුණාමලය ඇත්තටම මේ විශාල සංවර්ධන ව්‍යාපෘතියක් ක්‍රියාත්මක කරන්න ආරම්භ කරන්න සැලසුම් කරලා ඔක්කොම කරලා දැන් පටන් ගනිමින් ඉන්නවා. හැබැයි මේ පටන් ගන්න යනකොට කොතෙක් දුරට ජනතාවගේ සහභාගීත්වය, සිවිල් සංවිධානවල සහභාගීත්වය, දායකත්වය අරගන්න උත්සාහ කරලා තියෙනවද? උත්සාහ කරනවද? එහෙම නැත්නම් කොහොමද කොයි විදිහට මේ අය ක්‍රියාත්මක කරන්නේ කියන එක පිළිබඳව මීට වඩා ඇත්තටම අපිට සාකච්ඡා කරන්න වෙයි කියලා මට හිතෙනවා. මොකද අපි දකින්නේ ඇත්තටම එහෙම වැඩපිළිවෙලක් මේ ක්‍රියාත්මක කරන ක්‍රියාවලින් තුල අපිට පේන්නට නැති නිසා. අනිත් පැත්තෙන් ගත්තාම දැනටම ක්‍රියාත්මක කරලා තියෙන විශාල ව්‍යාපෘතීන් තියෙනවා අපේ රටේ. ඒක උදාහරණයක් මම ගත්තොත් උමාවේ වගේ ව්‍යාපෘතියක්. උමාවේ වගේ ව්‍යාපෘතියකින් ඇත්තටම රීසෙටල්මන්ට් කරුවා වැඩිමට ජනතාව රීසෙටල්මන්ට් කරා එක ස්ථානයක. ඊට පස්සේ තව කණ්ඩායමක් ඇත්තටම රීසෙටල්මන්ට් කරේ නැති වුණත් ඒ අයට පසුව ඇති වුණු බලපෑම පිළිබඳව විශාල ගැටලු රාශියක් මේ වෙනකොට මේ බණ්ඩාරවැල නගරය තුළ ජනතාවට මුහුණ දෙන්න සිදු වෙලා තියෙනවා. ඒතර මේවා ඇත්තටම හරි මේ පෙර සූදානමක්. ඒ කියන්නේ අපි මේ ප්‍රොජෙක්ට් එක සැලසුම් කරන තැන ඉඳලම මේවා ක්‍රියාත්මක කරන ක්‍රියාවලියේදී සැලකිලිමත් උනේ නැද්ද කියන එක ඇත්තටම අපිට තාමත් ප්‍රශ්නයක් වෙලා තියෙනවා. එහෙම වුණා නම් මේ දැන්ගෙන බලපෑම් වේල පහ ඇත්තටම හඳුනගන්න තිබුණා නේද කියන එක අපිට හිතන්න වෙලා තියෙනවා. මොකද ඊයේ මට කතා කරලා ඇත්තටම ආවේ කණ්ඩායමේ නායකයා කිව්වා මේ වෙනකොට ඇත්තටම සියලුම උල්පත් හිඳීගෙන ගිහිල්ලා ගෙවල් දොරවල් සාමාන්‍යයෙන් ඉරිත ඇලිලා පැලිලා විනාශ වෙගෙන යන එකක් සෑහෙන කාලෙක ඉඳලා තිබුණා. නමුත් දැන් මේ ගිය සතියේ ඉඳලා ඉවරහක් කළා විශාල දැවැන්ත වතුර හිගයක්. එහෙම නැත්නම් උල්පත් සිඳී යාමේ ක්‍රියාවලිය පටන් අරගෙන තියෙනවායි කියන එක කියනවා. ඒතර මේ කාරණාවල් තුනම ඇත්තටම අපි පොඩි විග්‍රහ කරගන්න වෙයි. අපි මේ ක්‍රියාවලිය විශේෂයෙන්ම නැවත පදිංචි කිරීමේ ක්‍රියාවලියේදී ජනතා සහභාගීත්වය කොයි මට්ටමින් අරගෙන තියෙනවද? අරගත යුතුද? එකක් අපිට සැලකිලිමත් වෙන්න වෙනවා. අනිත් පැත්තෙන් ජනතාවට තොරතුරු ලබා ගැනීමට තිබෙනා වූ අයිතිය කොතෙක් දුරට සනාථ වෙලා තියෙනවද කියන එක. විශේෂයෙන්ම දැන් අපි කියනවා RTI එක භාවිතා කරන්න පුළුවන් කියන එක. හැබැයි මගේ ප්‍රශ්නේ තියෙන්නේ මම ලංකාව පුරාම RTI වැඩසටහන් වලට දායක වෙලා තියෙනවා. ගොඩාක් වෙලා TISL එකේ උදව් අපිට අරගෙන අපි ඒ වැඩසටහන් කරලා තියෙනවා. මේ ප්‍රශ්නේ තියෙන්නේ RTI ක්‍රියාත්මක කරාට ජනතාවට මේ වෙනුවෙන් නොකඩවා සහභාගී වීමේ නොකඩවා ඒක ෆලෝ කරන්න තියෙන අවස්ථාව හරි අඩුයි. මොකද පළවෙනි RTI එක දාලා ඉවරහක් කළා ඒක කැන්සල් වුණොත් දෙවෙනි එක යාලා දාන්න උත්සාහ කරන්නේ නැහැ. ඒතකොට මේ ජනතාව කොතෙක් දුරට මේ වෙනුවෙන් පෙනී සිටින්න කැප වෙන්න සහ දායකත්වයේ දක්වන්න කැමති වෙලා තියෙනවද කියන එක අපිට තාමත් ප්‍රශ්නයක් වෙලා තියෙනවා. මොකද අපි සිවිල් සංවිධාන විදියට අපි මේ මට්ටම ගොඩනගන්න තවදුරටත් උත්සාහ කළ යුතුව තියෙනවා කියන එක තමයි අපේ අදහස විදියට අපිට කියන්න තියෙන්නේ. ඒතර මේ කියන කාරණාවල් එක්ක මම කැමතියි අතරම තවදුරටත් ඔබත් එක්ක මේවා සාකච්ඡා කරන්න. ඔබ අහන ප්‍රශ්නත් එක්ක මගේ අත්දැකීම් බෙදා ගන්නට. ඒ නිසා මම සූදානම් මේ වෙනුවෙන් ඔබට පුළුවන් මගේ ප්‍රශ්න අහලා ඉවරයක් කළා මගේ අත්දැකීම් තවදුරටත් ඔබ බෙදා ගන්න අවස්ථාවක් සලස ගන්න. බොහොම ස්තුතියි.
බොහොම ස්තුතියි ප්‍රියංකර. දැන් මම කතා කරන්නේ ශ්‍රියානි විජයසුන්දරට. ශ්‍රියානි විජයසුන්දර මම හිතන්නේ අපි ඉන්ට්‍රොඩක්ෂන් එකක් දුන්නා. CPA ආයතනයේ විශේෂඥයෙක් මේ වගේ ප්‍රශ්න පිළිබඳව. ඉතින් මම ආයිත් වැඩි විස්තර කියන්නේ නැතුව ශ්‍රියානි බොහොම ස්තුතියි අපිත් එක්ක එකතු වීම ගැන. මම දන්නවා පුතපේත තියෙන මම හිතන්නේ අත්දැකීම් සහ දැනුම ඉතාමත් වැදගත් වෙනවා අපේ සාකච්ඡාව පිළිබඳ අද. ඉතින් අපි විනාඩි 5ක් මම හිතන්නේ මේක තියෙනවා.
බොහොම ස්තුතියි වෙරිටි පරීක්ෂණ ආයතනයේ මේ සඳහා සාකච්ඡා කිරීම පිළිබඳව මේ ඉහතින් කතා කර අපේ සහෝදර ඊයේ සහ සහෝදරයා කතා කර දේවල් ඉදිරිපත් කළ ඉදිරිපත් කිරීම අපිට අපේ රටේ වර්තමාන තත්ත්වෙත් අපේ අත්දැකීම්ත් එක්ක බලනකොට සංවර්ධනය කියන එක පොඩක් ඉතරක් අමතක වෙලා අංගතයක් වෙලා තියෙනවා. ඒක නිසා එතම කියනවා නම් රටක සංවර්ධනයක් කියලා කියන්නේ මේත් එක්කම ප්‍රධාන අංශ රාශියක සාධනීය ප්‍රවේශයක් ඉන් යුක්ත විය යුතු ඉතා වැදගත් සමස්ත ක්‍රියාවලික ප්‍රතිඵලයක්. මෙන්න මේ අංශ අතර ඔබ මේ වැඩි අවධානය යොමු කරන යටිතල ව්‍යුහයන් ඉතාමත් වැදගත් අංශයක්. ඒ නිසාම මේ රටක සංවර්ධනය මේ පොදු යටිතල ව්‍යුහයන් අතර තියෙන්නේ අනුලෝම සම්බන්ධතාවයක්. එහෙම නැත්නම් direct relationship. මෙන්න මේ පොදු යටිතල පහසුකම් උවෙන් කතා කරා මධ්‍යම පරිමාණයෙන්, සුළු පරිමාණයෙන්, මහා පරිමාණයෙන් තියෙන්න පුළුවන්. නමුත් මේ යටිතල ව්‍යුහයන් ස්ථාපිත කරනකොට අපේක්ෂිත ප්‍රතිලාභින් ඇත්තටම මම නම් කැමති නැහැ කියන්න මගේ අත්දැකීම් වලට අනුව මේ ඒ ව්‍යාපෘති වලින් අගරුවට පත් නැත්නම් වින්දිතයන් බවට පත් වෙනයි කියලා අත ප්‍රොජෙක්ට් එෆෙක්ටඩ් කියලා අතන මට කියන්න ටිකක් එච්චර කැමති නැහැ. ඒ නිසා ඒ අපේක්ෂිත ප්‍රතිලාභීන්ට එම ප්‍රතිලාභ ලබා දීම සඳහා අනිවාර්යයෙන්ම ඇගයුම් කිරීම නැත්නම් මොනිටරින්, ඒ වගේම විමසුම් කිරීම, ඒ වගේම ඉවැලුවේෂන් ඒ විතරක් නෙමෙයි මෙන්න මේ වගේ විශ්ලේෂණාත්මක නියාමනයන් කිරීම ඉතාම වැදගත් වෙනවා. මෙන්න මේ සඳහා ඔබ සාකච්ඡා කළපු නියාමන රාමු විශේෂයෙන්ම සම්පාදනය, ඒ වගේම පාරිසරික බලපෑම් තක්සේරුව ඉතාමත් වැදගත් වෙනවා. මම දකිනවා මෙන්න මේ ප්‍රතිනිවාසන ක්‍රියාවලිය ඉතාමත්ම මැනවින් අපේක්ෂිත ආකාරයෙන් සකස් කරන්න නම් නැත්නම් අපේක්ෂිත ප්‍රතිලාභයට එය මනවින් ලබා දෙන්න නම් සමාජමය වශයෙන් ආර්ථික වශයෙන් ගැටලු ඇති නොවන නැත්නම් අවම වශයෙන් ඇති වෙන ආකාරයට ඇති වෙන්න නම් මෙන්න මේ සම්පාදන ක්‍රියාවලිය වගේම පාරිසරික බලපෑම් තක්සේරුව ඉතා හොඳ අංශ දෙකක් වෙනවා මේ ප්‍රතිනිවාසන ක්‍රියාවලිය සාර්ථක කරගන්නට. නමුත් හිතන්න නීතියකටවත් ගරු කරන්නේ නැති රටක නීතියක් ගැන තිබුණත් ඒ ගැන දැඩි අවධානයක් යොමු කරන්නේ නැති රටක ප්‍රසම්පාදනය තියෙන්නේ ගයිඩ්ලයින් එකක් විදියට. උපදේශක මාලාවක් විදියට. කෙසේ වෙතත් ඒක ගොඩක් පරණ එකක් විදියට. ඒ වගේම පාරිසරික බලපෑම් තක්සේරුව කරන ආකාරය අපි හොඳට දැකලා තියෙනවා. මේවයි ආරම්භක අවස්ථාවල් අපූර්වට මගහැරලා ඒවයි විවිධාකාර ෆේක්ස් රිපෝට්ස් විවිධ ආයතන වලට මේ රිපෝට්ස් ඇවිල්ලා මේ කරන දේවල් විතරක් නෙවෙයි දැන් ඔබ මේ කතා කරන යටිතල පහසුකම් පිළිබඳ විවිධාකාර ඉහළින් ඉන්නා වූ උදවිය අමුතු ආකාරයකට දකින්න හීනවල සුන්දරතාවය මත මේ යටිතල පහසුකම් සංවර්ධනයේ අනුලෝම සම්බන්ධතාවයක් දක්වුවට මේව හරි වේගවත් කරනවා කඩිනම් කරනවා හිතා ගන්න බැරි ස්වරූපයකට ඒ නිසා මේව කරන්නේ නිකන් විතරක් නෙමෙයි අර අපේක්ෂිත ජනතාව නැත්තම් මේවයින් මම නම් කියන අවසාන වශයෙන් දැන් දකින්න විදිහට මේවා ප්‍රාණකාරී විදිහට පත් වෙලා තියෙන්නේ මේ ජනතාව මේ ඔළුගේ ඔළුවට තියෙනවා මහා බලාපොරොත්තු ගොන්න. නමුත් මේ ගොන්න කොච්චර දුරට සාර්ථක වුණාද කියන එක අපේ ඉහත සාකච්ඡාවලදී තේරුණා. නමුත් මෙන්න මේ වගේ මේක කරන්නේ මෙහෙමයි මේ විදිහට විය යුතු කිව්වට අපේ බිම අපේ ග්‍රාමීය පසුබිම කොයි තරම් සූදානම්ද මේවා ලබා ගන්න, තේරුම් ගන්න, අවබෝධ කරගන්න කියන එක ගැටලුවක්. ඊළඟට මේවා එනවා විවිධාකාර විදියට පෞද්ගලික කාලේ මහා මාර්ග ජාලගත කරනවා, අධිවේග මාර්ග, දුම්රිය මාර්ග, ගුවන් තොටුපල්, වරායවල්, ශක්ති උත්පාදන කර්මාන්තශාලා, වාරි මාර්ග මේවා ඉදිකිරීම කරනවා, වැඩි දියුණු කරනවා. මේ සේරම කරගෙන යනවා. නමුත් මේ අපි දන්නවා මේවා පරමාර්ථය අතරම රටේ සංවර්ධනය උදෙසා බලනකොට ජනතාවගේ සමස්ත අභිවෘද්ධිය. මේ සඳහා මේවා කරන්න උත්සාහ කරාට බලාපොරොත්තු වෙන තිබුණාට රටට ඉඩම් නැහැ. එහෙම නැත්නම් ක්‍රවුන් ලෑන්ඩ්ස් නැහැ. මේ වැඩිපුර මේ ඉඩම් වල අයිතිකාරය වෙන්නේ අපේ මහ ජනතාව. මහ ජනතාව කියන්නේ අපේ රටේ ආදායමට, ජාතික ආදායමට නැත්නම් ඒකාබද්ධ අරමුදලට ආදායම් ස්වරූපය ශක්තිමත් කරන්න බදු මුදල් ලැබන අයිතිකාරයෝ. එහෙනම් ඒගොල්ලන්ට අයිතියක් තියෙනවා මේවා යන්නේ කොහටද මේවා වෙන්නේ මොකද කියලා බලා ගන්න. ඒ නිසා මෙන්න මේ ජනතාවගේ අවසානයේ ප්‍රතිලාභීන් උනාට ඒගොල්ලන් සංවර්ධනයේ වේගවත් භාවයත් එක්ක මම නම් දකින ජනතාව ප්‍රතිලාභී ස්වරූපයෙන් ඈත් වෙලා මම දැක්ක ඉරෝමිත් එක පැහැදිලි කරනවා වින්දිතයන් බවට පත් වෙලා තියෙනවා. අන්න එතනදී මෙන්න මේ ජාතික අනිච්ඡානුගත ප්‍රතිනිවාසන ප්‍රතිපත්තිය එහෙම නැත්නම් NIRP කියන එක ඉතා වැදගත් වෙනවා. හැබැයි මේ ප්‍රතිපත්තිය කොයිතරම් දුරට යාවත් කාලීනද නැත්නම් කොයිතරම් දුරට ජනතාවට සමීපද කියන එක ගැටලුවක්. ඒ වගේම තමයි මේ සියලු කටයුතු අතරතුර අර ප්‍රියංකර කිව්වා වගේ ජනතාව මොනවද දන්නේ? ඊළඟට ජනතාවත් එක්ක ඍජුව සම්බන්ධ වෙන සිවිල් සංවිධාන කොහේ දෙයක් තියෙනවා. ඊළඟට මේ ජනතාව මේවායේ නැත්නම් මේ ප්‍රතිනිවාසන වලට යන්නේ ඇත්තටම මම නම් කියන්න කැමති ඒවා නිකන් බලහත්කාරයෙන් වගේ. ඒක කර කියන දෙයක් නෑ. මොකද ඒ අයට එතනට යන්න සිද්ධ වෙනවා. නමුත් ඒ අයගෙන් නැති වෙලා යන දේවල් වලට ලැබෙන වන්දිය පිළිබඳව අද ජනතාව හූල්ලනවා. මම දැන් පහුගිය දවසේ කතා කරන වෙලාවක මම දැක්කා ඒ හූල්ලන ජනතාව. එහෙනම් අපි සිවිල් සංවිධාන විදියට නිසා කොහෙද ඉන්න ඕනේ කියන එක අපිට දැන් පේනවා. ඉතින් ඒක නිසා හැබැයි මම මේ අතරේ මම ඔබ මේ ගැන ඥානේ කරාද නැද්ද කියන එක 2001 විතර ලුණාව මතකද? ලුණාව සංවර්ධන වැඩසටහන කියලා. අන්න ඒ ප්‍රොජෙක්ට් එකේ ඒ කියන්නේ ලුණාව environmental improvements and community development project එක මට මතකයි 2001 2 වගේ කාලේ ඉන්නේ. අන්න ඒ ප්‍රොජෙක්ට් එකේ ඒක මේ මාර පාර්ට්නර්ෂිප් එකක් තියෙනවා ස්ට්‍රැටජික් පාර්ට්නර්ෂිප් එකක්. ඒ කියන්නේ ඒගොල්ලන් මට මතක විදිහට ජයිකා GOSL and UN Habitat මේ තුන් ගොල්ල එක එකතු වෙලා බොහොම පොඩක් සමබර විදියට මේ වැඩේ කරගෙන ගියා. ඒකෙදි මම දැකපු දේවල් මම හිතන මේකට දෙන එක ටිකක් හොඳයි කියලා පොඩ්ඩක්. එතනදී ගොඩක් ජනතාවගේ පාටිසිපේෂන් නැත්නම් ක්‍රියාකාරී සහභාගීත්වය එතන ගොඩක් තිබුණා. ඒක තමයි ගොඩක් මේ සුවිසල් නිශාන්ම කිව්වා සමස්ත මූල්‍ය ශක්තියෙන් තුනන් එකක් කාන්දු වෙලා යනවා කොහෙටද අපි දන්නේ නැහැ. අපි දන්නේ නැත්නම් කියන කාන්දු කියලා ඒකත් කාන්දු වෙලා යනවා. ඒවා ජනතාවගේ මුදල් ජනතාවට ලැබිය යුතු ප්‍රතිලාභ අන්න ඒවා. එතකොට නමුත් ජනතාව අදාළ සෑම වෙලාවකම සෑම තැනකදීම ක්‍රියාකාරී ස්වරූපයෙන් ඉන්නවා නම් සහභාගී වෙනවා නම් එහෙම නැත්නම් ක්‍රියාකාරී සහභාගීත්ව ප්‍රවේශයක් මෙහි තියෙනවා නම් මෙන්න මේකට ඉඩක් වෙන්නේ නැහැ. ඉඩක් වෙන්නේ මොකද මේක ජනතාවට දෙන්නේ වෙන කාටවත් නෙමෙයි. මේ ජනතාවගේ තන ජනතාවට ඕන විදියටයි ප්‍රකාශ වෙ යුත්තේ කියන එක මම ඉන්නේ. ඒ වගේ තමයි මෙන්න මේ වායශීලී මේ සහභාගීත්ව කරනවා. මේකට ඉතා වැදගත් මොකද ඒගොල්ලන් තමයි මේකට එක එක පදනම් සහ මූල්‍ය සැපයුම් කරන්නේ. ඒ අයගේ පාර්ට්නර්ෂිප් එකත් ඉතාම වැදගත්. ඒ වගේම තමයි අපිට තියාගන්න ඕනේ මේ සියලුම රීසෙටල්මන්ට්ස් වල නැත්නම් ප්‍රතිනිවාසන ස්ථානවල කාන්තාවන්ගේ දායකත්වයත් හරි වැදගත්. මොකද මේ ප්‍රතිපත්තියේ මූලධර්ම තියෙනවානේ 13ක් විතර. එයින් තුන්වෙනි මූලධර්මය කතා කරන gender equality and equity. අපි අද කතා කරන එක. හැබැයි මේක ප්‍රතිපත්තියක් නේ, පොලිසි එකක් නේ. බලන්න මම උදාහරණයක් කියනවා නම් 2011 පළාත් පාලන ඡන්දේ අපි දැක්ක කාන්තාව හිටියේ පළාත් පාලන ආයතන 59 දෙනෙක්. 0.8යි 1.8යි කාන්තා නියෝජනය. නමුත් 2018 වෙනකොට කාල අරගලයකින් පස්සේ ගේනවා 25% 25 කෝටා එක. ඒ 25 කෝටා එක නිකන් නෙමෙයි ගේන්නේ නීතියක්. අන්න ඒත් එක බලන්න නිසා කොලීග්ස් බලන්න ඒ නීතිය හරහා අනිවාර්යයෙන්ම පළාත් මගෙන් අහන්න එපා මේ ක්වොලිටි එක කොහොමද කියලා. කාන්තාව රාශියක්. ඒ කියන්නේ 59 දෙනා 1926ක් දක්වා වර්ධනය වුණා පළාත් පාලන ආයතන. කියන්නේ 120%ක වර්ධනයක් ඇති වුණා 122ක වෙනස් වීමක්. එතකොට අපි හිතන්න නිශාන්ත අපේ කොලීග්ස් හිතන්න නීතියකට ගරු කරන්නේත් නැති නීතියක් සත පහත් වෙලාවට ගණන් ගන්නෙත් නැති රටක ප්‍රතිපත්තියකින් මේක කරන්න පුළුවන්. ඉරෝමිත් පැහැදිලි කළා මේකට නෛතික ප්‍රවේශයක් ඉතාම ඉක්මනට අවශ්‍යයි. මොකද රීසෙටල්මන්ට්ස් නැත්නම් ප්‍රතිනිවාසනය කියන්නේ ප්‍රියංකර කිව්වා වගේ සංවේදී ඉතාමත්ම සංවේදී තරම්. මම හරියට ඒක මේ සම්බන්ධ කරනවා ගංගා ද්‍රෝණියක එහෙම නැත්නම් කැච් රිවර් කැච්මන්ට් එකක් හරියට. අන්න ඒ වගේම තමයි සෙන්සිටිවිටි එකක් තියෙනවා මෙන්න මේ ප්‍රතිනිවාසන කාර්යය. මොකද අපි වෙන තැනකට ගිහිල්ලා වර්ක්ෂොප් එකක් කරලා ට්‍රේනින් ප්‍රෝග්‍රෑම් එකක් කරලා එනවා වගේ එකක් නෙමෙයි මේක. මේකදී අපිට මේ අවුට්පුට් එක ඩිරෙක්ට් අවුට්පුට් එකක්. අපි මේක දකිනවා. අපි යතුරු බාර දෙනවා ගිහිල්ලා ජනතාවට. ජනතාව සතුටින්ද කියන එක මට ප්‍රශ්නයක්. කෙසේ වෙතත් නිවස්නයකට යනවා. ඒක බලහත්කාරක විදිහට නිවස්නයකට යනවා. ඒක අපි දකිනවා. හැබැයි මේ අවුට්පුට් එක අවුට්කම් එක දක්වා නැත්නම් ඉහළ මට්ටමකට එනවා නම් ජනතාවගේ හැසිරීම විලාසය කොයිතරම් සාධනීයද කියන එක අතිමහත් ගැටලුවක්. ඒ වගේම තමයි මම දැක්කා අර ලුණාව කතාවේ CBOs ඒ පරිසරය තුලම නිර්මාණය වුණා. අන්න එතකොට අර ඒ කියන්නේ formation of CBOs ඒ ජනතාවගේ පරිසරය තුලම එතකොට ජනතාවට දන්නවද අපි ට්‍රස්ට් එක ගැන කතා කරලා වැඩක් නැහැ නිසා. අපි කතා කරන්න ඕන කොන්ෆිඩන්ස් එක. ජනතාවගේ පොක්කේ එන හැටි ගැන කොටිම කියනවා. ඇත්තම කියනවා. අන්න එතන තමයි ප්‍රශ්නයක් තියෙන්නේ. එතන නිසා තමයි අද අපි කතා කරන ගැටලු ගොඩක් ඒක රාශි වෙලා ස්ටැග්නේට් වෙන පල් වෙන එකට. ඒක නිසා අන්න ඒ එන්වයරන්මන්ට් එක ඇති කරා. අන්න ඒ එන්වයරන්මන්ට් එක නැත්නම් ඒ ලාක්ෂණික තත්ත්වයන් හොඳින් තිබෙනවා නම් විශේෂයෙන්ම පාර්ටිසිපේටිව් අප්‍රෝච් එක නැත්නම් සහභාගී ප්‍රවේශය හැම තැනදී ඒක ක්‍රොස් කටින් කියලා මම නම් කියනවා. ඒ අප්‍රෝච් එක තියෙනවා නම් මෙන්න මේ හෑන්ඩින් ඕවර් එක මේ ප්‍රතිනිවාසන ජනතාවට බාර දීම හරි ස්මූත්. හරි ස්මූත්. නමුත් එහෙම ස්මූත් එකක් අපි දකිනවා මේවයි. එහෙම නැත්නම් මේක බාර දීලා ටික දවසකින් මොකද වෙන්නේ? අපි පහුගිය දවස්වල මාධ්‍යයෙන් හැමතැනම දකිනවා වතුර නැහැ, අරක නැහැ, මේක නැහැ, විදුලි බලය නැහැ. මේ වගේ ජනතාවට ගොඩාක් ප්‍රශ්න වලට. ඒ වගේම සෝෂල් අන්රෙස්ට් දැන් විශේෂයෙන් මේ වසංගතයත් එක්ක ඒගොල්ලන් එක්කම තැන. මොනවද අපි හිතලා තියෙන්නේ ගැන? කවුද හේතුවේ? එතකොට මේ ඔබ්ජෙක්ටිව්ස් මෙතන පහක් තියෙනවා. මූලධර්ම 11ක් තියෙනවා. උවින් කිව්වා වගේ මේ මූලධර්ම 11 අර මේ හරියට මට නම් මේක දකින්නේ දියැලක් පල්ලෙහාට වැටෙනවා. දියැලක් පල්ලෙහාට වැටෙන වැඩක් නැහැ බිම හරියට නැත්තම්. නැත්නම් ඒක ගලාගෙන යනවනේ මූදෙට නැත්නම් කොහෙද ගාකට ගලාගෙන යනවා. ඒකෙන් හරියට වැඩ ගන්න බිම හැදිලා තියෙනවා. ඒක නිසා මෙන්න මේ මූලධර්ම ටික හොද්දට භාවිතා කරනවා නම් අන්න එතන සාර්ථකත්වයක් ඇති. නමුත් අපිට පේන මට නම් දකින්න තියෙනවා මොනිටරින් කියන එකක් මේ ප්‍රතිපත්ති වල පොතේ තිබුණාට යථාර්ථයේ නැහැ. ඉවැලුවේෂන් එකක් නැහැ. නියාමනය කරන ඕනේ ආයතන විතරයි. ඊළඟ මේවා කතා කරන. හැබැයි මේ කතා කරාට මට දුකයි මේක කොච්චර දුරට අතුරට උකහා ගන්නවද කියන එක පිළිබඳ ප්‍රශ්නයක්. කවුද මේවා උකහා ගන්නෙ? මේවා ඊළඟ මොනිටරින් ඇන්ඩ් ඉවැලුවේෂන් ෆ්‍රේම්වර්ක් එකක්. එහෙම එකක් තිබුණා නම් අපිට දකින්න පුළුවන්. නිසන් ඔයාටත් මටත් අපි හැමදේටම බලන්න පුළුවන්. කවුද මේකට වග කියන්නේ? කවුද මේවට වග වෙලා ඉන්නේ?
ශ්‍රියානි මම හිතන්නේ මේ ඉතාමත් හොඳ අදහසක් මම ඉන්ටරප්ට් කරේ ශ්‍රියානි අපි තවත් කතා කරමු ප්‍රශ්න කරන වෙලාවේ හැබැයි ශ්‍රියානි මම දන්නවා CPA එකේ මොනිටරින් ඉවැලුවේෂන් ප්‍රධානියා හැටියට වැඩ කරනවා එකෙන් ලොකු අත්දැකීමක් තියෙනවා ඇත්තටම මේ වෙන සිද්ධි කාටවත් නොපෙනෙන විදිහට අයුක්තිය ඇති වෙන්නේ නේ ඒ කියන්නේ මේ වගේ වැරදි විදිහට රජය හෝ මේ ප්‍රතිපත්ති නියාමනය කරන එක අපි දන්නේවත් නැහැ කියන එකයි ශ්‍රියානි කියන්නේ ඒක මම හිතන්නේ ඉතා වැදගත් දෙයක්. මම දැන් අපි සෙනිත්වයි උවින්වයි සුභාෂිනීවයි කතා කරමු අපේ පැනල් එකට එකතු වෙන්න කියලා. එතකොට මේ මම පොඩ්ඩක් කිව්වොත් ඉරෝමි ඇහුවා මෙහෙම ප්‍රශ්නයක් මේ public purpose කියන එක. What is a public purpose කියන එක. මම හිතන්නේ ඒකට හොඳ උදාහරණයක් තියෙනවා. ඒක වැරදි විදිහට නැත්තම් අයුතු විදිහට අර්ථකථනය කිරීම ගැන අර water's edge කියන මම හිතන්නේ මේ ප්‍රොජෙක්ට් එක public purpose වලට කියලා තමයි ජනතාවගෙන් ඊටම ගත්තේ. ඊට පස්සේ ඒක අතරම ප්‍රයිවට් පර්පස් එකක් වගේ තමයි ඒක ඉදිරියට ගියේ. හැබැයි එතනදී මම හිතන්නේ සුප්‍රීම කෝට් එක ඒක රිවර්ස් කරා. ඒක වැරදි කියලා තේරුම් ගත්තා. ඉතින් අර ජනතාවත් එක්ක සාකච්ඡා කිරීමේ තවත් වැදගත්කමක් තමයි මේ පබ්ලික් පර්පස් එක ඇත්තටම අපි ආණ්ඩුව සාධාරණ විදිහට ඉදිරිපත් කරන්න ඕනි කියන එක මම හිතන්නේ ඉතා වැදගත් දෙයක්. හැබැයි දැන් මම මේකට ටිකක් විරුද්ධ ප්‍රශ්නයක් අහන්නම්. මොකද දැන් අපි ඔක්කොමලා එකග වෙලා වැඩක් නැහැ. මේකට එකග නොවන කට්ටියක් ඉන්නවා. හරි. දැන් ආර්ථික විද්‍යාවේ අදහසක් තියෙනවා කියන පරේතෝ ඔප්ටිමැලිටි කියලා. ඒ කියන්නේ අපි කියන්නේ හැමෝම යම් විදිහට හැමෝටම යම් බෙනිෆිට් එකක් තියෙනවා. හරි. යම් සම්බන්ධයක් තියෙනවා. කාටවත් අගුණයක් නැහැ. හැමෝටම යම් ගුණයක් වෙන දෙයක් කළ යුතුයි කියන එක. හරි. දැන් මේ වගේ විශාල ව්‍යාපෘති තියෙනකොට අපි යම් අදහසක් තමයි. ඇයි මේ පබ්ලික් පර්පස් කියන නීතිය තියෙන්නේ? මේ කියන්නේ මේ ඇත්තම සමස්ත ධනාත්මක ගුණය මෙතන සෑහෙන දුරට තියෙනවා. ඒකින්ද එක්කෙනෙක්ට මේකේ ඍණාත්මක ප්‍රතිඵල වලට එයාට කම්පෙන්සේට් කරන්න පුළුවන් කියන එක. හරි. හැබැයි දැන් මෙහෙම ප්‍රශ්නයක් තිබුණොත් ප්‍රියංකර මම ඔයාගෙන් අහන්නේ දැන් අපි ගොඩක් වෙලාවට මේක හිතන්නේ ආර්ථික අගය පැත්තෙන්. හරි. ඉතින් දැන් තමාට වෙන ආර්ථික මම හිතන්නේ ප්‍රශ්න විසඳ ගන්න පුළුවන් නැත්නම් ආර්ථික ඍණාත්මක ප්‍රතිඵල වලට ගැළපෙන විදිහට අපිට කම්පෙන්සේෂන් එකක් දෙන්න පුළුවන් කියන අදහස තමයි තියෙන්නේ. ඒක තමයි ලාක් ප්‍රතිපත්ති වලත් හැද ගහලා තියෙන්නේ. හැබැයි ප්‍රියංකර කිව්වා දැන් මේකට ආර්ථික අගයක් නෙමෙයි මානසික අගයක් වෙනම තියෙනවා. මගේම ඉඩමට පය ගහන්න ඕනේ කියන අදහස තියෙනවා. දැන් එක පුද්ගලයෙක් යම් මේ කියන්නේ සමාජයටම කියමු අපිට විශාල මේ හයිඩ්‍රෝ ඩෑම් එකක් දාන්න පුළුවන්. හයිඩ්‍රෝ පවර් දීලා මුළු රටටම ඉලෙක්ට්‍රිසිටි මිල සෑහෙන විදිහට අඩු කරන්න පුළුවන්. හැබැයි එක පුද්ගලයෙක් මේ මෙතන මැද ඉඳලා කියනවා නෑ මට මගේ ඉඩම අත්හරින්න බෑ මට කොච්චර සල්ලි දුන්නත් මිලියන 10ක් 20ක් 30ක් දුන්නත් 100ක් දුන්නත් 200ක් දුන්නත් මම යන්නේ මට මගේ ඉඩම අගය කරනවා. එතකොට ඒකත් ඒ වගේ වෙලාවකට අපි කොහොමද මේක ගැන හිතන්නේ? ඒකත් සාධාරණද නැත්නම් ජනතාවගෙන් කියන්නේ සමස්ත ජනතාවට එක පුද්ගලයෙක්ගෙන් ඉල්ලන්න පුළුවන් දෙයක් තියනවාද? එයා එකග නොවුණත් ඒ වගේ මතයක් උඩ එතන සාධාරණත්වය ගැන අපි හිතන්නේ කොහොමද කියන ප්‍රශ්නේ මම අහන්න කැමති. මම හිතන්නේ ඉරෝමි ප්‍රියංකරයි ඒකට උත්තර දුන්නොත් ඔව් ප්‍රියංකර ඉස්සලා.
ඔව් මම හිතන්නේ ඇත්තටම ඔබතුමා කියන කාරණාවේදී ඇත්තටම අපි සංවර්ධනය එපා කියලා කියන්නේ නැහැ. හැබැයි සංවර්ධනයේ ප්‍රතිලාභය කා සඳහාද? ඇත්තටම සංවර්ධනයේ ප්‍රතිලාභය කා සඳහාද කියන එක තමයි අපිට වැදගත්ම කාරණාව. ඒතකොට සංවර්ධනයේ ප්‍රතිලාභය ලැබෙනවා නම් ජනතාව ඇත්තටම මේ වෙනුවෙන් කැපකිරීමක් කරන්න කැමති. හැබැයි සංවර්ධනයේ ප්‍රතිලාභය ජනතාවට නොලැබෙනවා නම් එයාලා ඒක කැප කරනවා නෙමෙයි එයාලා බලහත්කාරයෙන් අයින් කරන්නේ. දැන් සරල උදාහරණයක් ගත්තොත් දීවර කර්මාන්තය කරන පිරිසක් වෙරළබඩ ඉන්න පිරිසක්ව සංචාරක පුරවරයක් කරන්න කියලා ඉවරහක් කියලා සංවර්ධන සැලැස්මක් ඇවිල්ලා ඒ කණ්ඩායමට කියනවා ඔයාලව අපි ගිහිල්ලා රීසෙටල් කරනවා කිලෝමීටර් 7ක් දුරින්. හැබැයි හොඳ තට්ටු නිවාස හදලා එතන පදිංචි කරනවා. දැන් මං කියන්නේ ඒක සාධාරණද? මං කියන්නේ ඒක කිසිසේත් සාධාරණ වෙන්නේ නැහැ. මොකද හේතුව ඔහුගේ ජීවන කර්මාන්තය සම්පූර්ණවම බිඳ වැටෙනවා එක පැත්තකින්. අනිත් එක එයාගේ සමාජ ආර්ථික පරිසරයම බිඳ වැටෙනවා. මොකද එයා ඉන්නේ රළත් එක්ක, ඒ ශබ්දයත් එක්ක, ඒ මුහුදත් එක්ක ගැටෙන පුද්ගලයෙකුට එතනින් එහාට ගිහිල්ලා ඒ වැඩේ කරන්න බෑ. අපි ඔක හොඳටම දැක්ක සුනාමි වෙලාවේ. මම හිතන්නේ හොඳම අත්දැකීම අපිට තියෙන සුනාමි වෙලාවේ. ඕකම කරා සුනාමි වෙලාවේ මුළු දකුණෙම. හැබැයි අද වෙනකොට මේ මිනිස්සු ඒ තමුන්ගේ ටෙම්පරරි හවුස් ටික ගහගෙන එහෙම නැත්නම් ගෙවල් ටික හදාගෙන උණු තැන් ටික අද වෙනකොට සංචාරක ව්‍යාපාරයට දීලා තියෙනවා. එතකොට කෙරුවේ ආණ්ඩුව බොරුවක්. කියන්නේ මම කියන්නේ එහෙම කරන්නේ නැතුව මිනිස්සුන්ට ඇත්තම කියලා. හැබැයි එහෙනම් ඒක අවදානම් කලාපයක් කියලා නම් කරලා ඒ කෑල්ල එහෙමම ඉතුරු කරලා අර මිනිස්සුම අතන පදිංචි වෙලා කාලෙන් කාලට ඇවිල්ලා අපි කියන්නේ සංක්‍රමණික විදියට මයික්‍රම් විදියට ඇවිල්ලා තමුන්ගේ වැඩේ කරගෙන යන්න පුළුවන් සිස්ටම් එකක් හදන්න.
දැන් මම කියන්නේ බොරු කියලා. ඇත්තටම පේන විදිහට අසාධාරණ දෙයක් කරලා පබ්ලික් පර්පස් කියන එක අයුතු ලෙස විග්‍රහ කිරීම ඒවා අපි තේරෙන ප්‍රශ්න. හරි. හැබැයි මගේ උදාහරණය ගත්තොත් ඒ කියන්නේ මේ සමහරක් විට කවුරු හරි කියනවනේ මට කමන්නේ මුළු ලෝකයටම උනත් උදව් කරන්න පුළුවන් උනත් මගේ ඉඩම මම දෙන්න කැමති නැහැ. එහෙම අවස්ථාවක් ගැන අපි නොහිතිය යුතුයිද? මං ඉරෝමිගෙන් අහමුද අපි ටිකක් ඒකට
නෑ මම කියන්නේ ඒකට මම චූටි උත්තරයක් දෙන්න. මම කියන්නේ එහෙම හිතන්න ඕනේ නෑ. මොකද ඇත්තටම මිනිස්සු එහෙමම නරක නැහැ. මං කියන්නේ එහෙම නරක නැහැ. මොකද අපි ඕන තරම් අත්දැකීම් අපිට තියෙනවා එහෙම. තමුන්ගේ දේවල් කැප කරන්න කැමති බොහෝ දෙනෙක් වෙනුවෙන් කියන තැන ඉන්න බොහෝ දෙනෙක් ඉන්නවා ඇත්තටම. එහෙමම මම කියන්නේ අපිට මෙයා කරන්න බෑ. හැබැයි අර මං කියපු කාරණාවල වලට යටත් ඒ අයට ඇත්තටම මේ ප්‍රතිලාභයේ භුක්ති විඳින්න ලැබෙනවා නම් ඒ කැපකිරීම කරන්න සූදානම් මිනිස්සු.
ඒක හොඳ උත්තරයක්. ඒ කියන්නේ මේ ප්‍රියංකර කියන්නේ අපි මිනිස් ජනතාවගේ සාධාරණ දැක්ම පිළිබඳ අපිට විශ්වාසයක් තියෙන්න ඕනේ. ඒ කියන්නේ ජනතාව කියන්නේ සාධාරණයෙන් අපිට යම් විදිහකට ගමනක් ගෙනියන්න පුළුවන් බව ඒ විශ්වාසය තියාගෙන වැඩ කිරීම ඉතාමත් වැදගත් කියලා. Iromi, do you want to add anything to that? Yeah.
Thanks, Nishan. I think I also echo Priyankara's sentiments. I work many communities, particularly in Colombo, and I have to date never heard anybody say we don't want to give up our land for a development project. What everyone says is we are willing to give up for development, but what we want is a fair process. We want what is due to us in a fair way. We want to be heard. We want our voices to be heard, and we want to know that our what we are giving up is not going to be in vain. And at the end of the day, what people are giving up is their home. And Sri Lankans have a particularly interesting tie or identity that is built around their land. When we ask people, how, do you own this land? Nobody ever says, yes, I have a title deed. They don't come and say, oh, mata sinnakara oppuwak tiyenawa. They say, I was born here. My parents were born here. My grandparents built this house. My grandfather planted that mango tree in front. They identify with land in a particular way. So you can't see, when it comes to development projects and land acquisition, you can't see things in black and white in the way that the law dictates. And I think that is also where a huge amount of problems that we see. That being said, we do see a lot of resistance, and that usually does come from where the process is extremely unfair. And in Sri Lanka, what we see is that, everything has to be in a rush. Everything has to be shown at the end of a 5-year election cycle so that someone can go and say, I did this. I built the tallest, I built the highest, I built the largest, and I did this. So, if you're going to meaningfully consult with people, that's going to take time. Sometimes consultations can take years. And some of the most successful projects that we've seen in Colombo, where communities were resettled, actually were a few years in just consultation process. But unfortunately, the way that the political game here is played, there is no room for consultation. So if you don't like it, either you get evicted, you get threatened, you get harassed, or that you get threatened by this will take you to court, and the last thing anybody wants is that kind of retaliation. So either way, people end up leaving. And just I agree with Priyankara. I have genuinely never heard anyone say they're against development, and no matter how much of a tie they have to the land.
That's a very encouraging, I think, thing to hear, because you're so connected to these negotiations. I'm going to let Uween make kind of a final response on the NERP side. Y'all call it NIRP. I use NERP for short. And then we'll move on to the procurement-related questions and maybe come back to y'all on thoughts on that as well. Just because I want to make sure we give fair time for questions on procurement as well. Uween, do you want to say anything further to the questions that have come up that you've seen earlier and to what the panelists have said? And after you, we'll ask Subhashini whether she wants to discuss anything further on NERP as final comment or whether we move on to procurement from there. Over to you, Uween.
No, I definitely agree with most of what the panelists have said. And just to clarify one particular thing about one of the questions that was raised regarding the resettlement action plan, I think it's important to clarify that even the resettlement action plan, like I said, even though it's crucial, and I said that it's not even disclosed, I also want to clarify that there is actually no legal requirement to in fact even do a resettlement action plan. So let alone disclosing it, you don't even have the obligation to even actually have a resettlement action plan. So that goes to show how kind of poor the legal framework, or how sort of how many gaps, or how weak the legal framework is when it comes to sort of protecting people who are subject to involuntary resettlement. In terms of the NIRP, yeah, so I definitely, I mean, like Iromi quite correctly pointed out, it is definitely one of the key pieces of policy that we have in Sri Lanka. It's quite comprehensive, even though, yes, there are quite a few shortfalls in it in terms of how it aligns with current international best practices. And it is extremely disheartening to see that even almost now 20 years down the line, we still don't see those principles being given any kind of legal recognition. We still don't see those things as being sort of obvious things that should be part of the discourse. That they should be sort of basic principles, or sort of things that should by now be sort of well entrenched in the institutional framework. And it is quite unfortunate that we haven't. So that the NIRP hasn't come into being. So definitely echo those sentiments. And yeah, so like I said, like I pointed out at the start, there's no point about sort of going ahead with development. There's no point to sort of getting more loans or getting whatever for development projects if at the same time we don't necessarily think about what the costs that involuntary resettlement brings about, and without trying to mitigate those costs, just proceeding on a development agenda won't necessarily bring value for money, and isn't necessarily socially sustainable either. So I think with that, I'd like to conclude. Subhashini, is there anything else that you would like to add?
Thank you, Uween. I think thank you for the panel for all the great comments and observations. And I do agree. I think one of the issues what I wanted to comment on what Senith said about the deviations from competitive bidding and the justifications, we seem to be still very preoccupied with price, right? So even the deviations, Senith clearly says lowest price or reasonable price. But I think today the discussion on procurement and infrastructure is a lot about lowest bid being the best bid is no longer the benchmark we are going for. The aspects that we will be talking about tomorrow on environment, and the areas we discussed today on equity and social costs and social impacts are very much part and parcel of value for money. So when a bid comes in, I think, Senith, correct me if I'm wrong, I think procurement guidelines still focus on economy, efficiency, and effectiveness. They don't spell out in the value for money the environment and the equity aspects. I believe the 2019 procurement guidelines that is not passed in Parliament yet, so which is not effective, still talks about the green procurement. But in the current procurement guidelines, there isn't emphasis. But we know today that if we fail to incorporate environment aspects, the social aspects into the procurement and the infrastructure, it's important that the bidders are evaluated not just based on their price, but there are many other elements to bid evaluation that needs to come in. And I think that is what we are discussing today as well. So their plans, their proposals need to incorporate some of these things. But I believe involuntary resettlement, land acquisition, compensation happens before the tendering, right? So it falls into the responsibility of the government. And that must be completed before we go into calling for bids and calling for evaluating bidders. So it's very important to really understand the value of it. But unfortunately, one of the problems today, like Iromi identified, is we are in a hurry to develop, implement projects. At the same time, I think we seem to consider some of these procurement preparedness activities as tick the box exercises. We don't really see the value of it, that there is a purpose and an outcome that is expected, but we seem to think, oh, I need to tick the box, so I need to somehow get this. Otherwise, according to the procurement guidelines, you can't even call for a procurement committee and you can't call for tendering. So there is a hurry to tick the environment impact assessment box, tick the land acquisition box, and then go into procurement and do the projects, which is unfortunate. So I think it's very important that our attitudes and thinking around development, like Shreyani said, needs to change, and we need to see the infrastructure from a public interest perspective than political interest perspective, like Iromi highlighted. So over to you, Nishan. Maybe Senith can address some of the comments and observations, and also Mr. Chandrajaratna really raised some very important points, saying that, you know, there are many other aspects than the problems that we've highlighted that undermine value for money. And maybe, Senith, you can say that what you highlighted today is only a glimpse of some of the issues identified in the report. Maybe you can elaborate a little bit more on some of the other aspects covered. And thank you, Ms. Jayaratna, for highlighting those issues.
So I'll let Senith then take over and respond to Mr. Chandrajaratna's comments, which were on the, and Senith, maybe you want to just repeat the question or comments for people who are not on this call, but are following us on social media, and then respond to them. Yeah. You're on mute.
Yes, thank you, Nishan. Thank you, Subhashini. So maybe I'll start off with a question by Namal Alpanava. So that was regarding whether the national guidelines have a definition for national competitive bidding. So interestingly, there is no explicit definition of national competitive bidding in the procurement guidelines, the manuals, or even in the CEDA bidding contracts. So firstly, NCB is used in situations like I mentioned before, where nationally bidders are called for, and that's for local bidders. But the manual also specifies situations where the foreign funder mandates national competitive bidding. So that is something that wasn't covered in the presentation. So that is a scenario which is similar to a national treatment scenario, where foreign bidders bid with the same conditions and the same process and same rules as local bidders. So that is where maybe national competitive bidding can have two interpretations based on the way it's applicable. So the reason why there is a national treatment element in the foreign funder situation is because in ICB, international competitive bidding, the national guidelines say that a domestic preference criteria can be used to give a certain leeway to domestic bidders. So that is the situation when it comes to definitions. I hope I have answered that question. So
Senith, I'm going to interrupt on this bidding issue, right?
Yeah.
Now, and I'm kind of going to invite Namal if she wants to jump in on this question as well. You said that we had laws, and Subhashini also said, that basically say that normal procurement guidelines can be suspended when it's an international bid and there is international funding. Now, I'd like to understand, I think for the sake of the audience also, the basis for that carve out. Is it because, and there could be two reasons, is it because there is a view that international donors have that their procurement processes are superior and they wouldn't be giving Sri Lanka funding or financing at a concessionary rate without adopting those superior procurement methods? So they realize that you can't change the laws in the country and you'd like to adopt. Is that the reason for the carve out? Or is the carve out more insidious, that it is that there is a more inferior or a more selective process that is being envisaged, and that people, because they're giving you concessionary financing, would like a more like some restrictions that are not quite fair play? And so what is the legal kind of justification for such a carve out? Because Sri Lanka can't be exceptional in that context. And I think I'd like to have maybe you, Uween, Subhashini, have any thoughts on that, but I actually maybe even Nama to jump in from the audience, because I'm sure there's a lot of knowledge there as well. Go ahead.
Right. So I'll just give a brief point of view from my end, and then I think Namal has also raised her hand. So with regards to intentions, Nishan, all I can say at the moment is that when the procurement guidelines were drafted in 2006, it was a consultative process which included multilateral funders who had also come on board. So there was a lot of consultation as far as we can see at least from the reports, when formulating these guidelines. And to a great extent, when we look back at 2006, the guidelines reflect a lot of the principles that were there in the multilateral agency guidelines, like World Bank and ADB, who were also part of the process. But however, when it comes to application, Nishan, that is where I think the basis for your question also comes from, because there is, let's say there are two situations where, of course, one situation is where the deviations end up with the result of the deviations could be having higher standards than local standards. I think one of the reasons is because the guidelines that are still in force are from 2006. So naturally, there are higher standards or more accurate standards that especially multilateral and even bilateral up-to-date procurement guidelines would have. And secondly, also we have situations where there are, let's say, lower standards, especially when it comes to the competition element. That is, as highlighted in the presentation, we could see that a lot in bilateral loans. Of course, that is because when there is a bilateral loan, the foreign lender also has their interests. So it's hard to say whether, so at the moment, so we are not saying whether it's good or bad, but the impact is such that there is a deviation for competitive bidding. So the basis actually comes from 1.3.3 of the procurement guidelines, which specifically state that when a foreign funding guideline is there in a foreign funder, that would particularly take precedence. I would maybe expand more after maybe Subhashini or Namal also talk about it.
Just to add to Senith before we give the floor to Namal, who is obviously very knowledgeable and has many years of experience than either me or Senith on the matter. But I think, Nishan, it is important to acknowledge that when you say guidelines, not every foreign lending agency has guidelines. Some foreign lending agencies have procurement guidelines published and others don't. So their procurement is really governed by the loan agreement. And actually, more than the procurement guidelines, when it comes to deviations from competitive bidding, the loan agreements and the conditions in the loan agreement plays a critical role. So in the multilateral agencies, the guidelines are definitely saying you should go for international competitive bidding in most instances. And another area of guidelines that we need to think about is the ones that I think Priyankara and Iromi and others are a lot more familiar with. It's about environment, social compliance. The foreign funding agencies that does have published social and environment frameworks actually demand Sri Lanka to adhere to better standards and higher standards than what is within the national framework. I'm sure Priyankara and Iromi has experience and comment on it, and I will let Namal also add her observations and comments. Over to you, Namal.
Namal, are you able to unmute and speak?
No, I'm fine. So thank you very much. Actually, the one point I was going to make was already raised, but yes, not all the FFAs have, or not all the funding agencies have procurement guidelines in the first place. It's the multilateral banks that usually have it. From the bilaterals, as far as I know, it's probably only JICA. So then in that sense, the objective of the guidelines are the same, because we want to hold the procurement to a certain international standard in transparency, in competitive, the openness for competition, and so on and so forth. And we do find that there are certain gaps in the national procurement guidelines. So, and then it's too complicated for us to take bits and pieces and say, okay, this part you take from here, this part you take from there. So, and also the thing with procurement guidelines is procurement guidelines always go hand in hand with the bidding documents that you're supposed to use, right? So we do not have, or the Sri Lanka doesn't have let's say, okay, if you take the CEDA documents, that is not really in line with any international bidding document exactly, right? It may be based, but there are deviations. So, so in the end, the objective of holding the borrower to the guidelines is because we have analyzed that our guidelines are at a higher standard and we need to, it's mandatory for us to hold the procurement to that standard. Then the certain restrictions to the eligibility to bid, those are normally coming from the loan agreement and not from the guidelines, because all our guidelines are based on doing international competitive bidding, which is the most open bidding type of bidding that is available, right? So the restrictions now, one point, the reason I asked about the definition to national competitive bidding is you, by definition or by the name itself, one could say that that itself is a restriction. Because as I understand, the government's understanding of national competitive bidding, as shown in Senith's presentation also, it's kind of expected to be restricted to Sri Lankan nationals, right? So one could say, and also, little point on Senith's presentation again, one cannot say just because it's a Sri Lankan company that you're going to have a price less than anybody else. It's not the case anymore, right? So then the reason that you restrict to a certain nationality would be other reasons, which may be justifiable, I don't know. But the point is that what I want to say is, I think we cannot say just because competition is restricted, that by itself is not always all bad. You need to always think what was the reason of that restriction, and with that restriction, do you end up in a better deal for the public? Right, I would, so I think when most of the time we go around saying tied loans are bad or restricting the bidders who can bid are bad, we are kind of losing the forest for the trees, because sometimes restriction may work out in a better way for you. So, for example, I suppose sometimes the reason that there is national competitive bidding and it's restricted to Sri Lankan nationals is in order to make sure, even at a higher price, that the job goes to a local company, which may be the policy in order to develop a certain industry and may not be bad, right, overall. So, but just a clarification, when we, at least JICA, when we say national competitive bidding, we do not allow domestic preference, nor do we allow restriction to only Sri Lankan nationals. Our definition of, we actually call it local competitive bidding, is that you do the same thing as what you do in international competitive bidding. There is no restriction, except that under the understanding that this particular procurement only that international, so bidders outside the country may not be very interested. We allow certain things like having a shorter bidding period, or I don't know, shorter bidding period, maybe do not have to publish it in an international newspaper and so on and so forth. But it's international bidding done locally. That is what we mean.
Thank you, Nama. So
yeah.
I think the preferential, the positive preference for local companies is understood in the sense of the positive externalities that come from, as you're saying, the public good that generates from creation of employment, know-how, all that for local firms and local people. And so that may be seen as a positive override that's given. I just wondered whether Subhashini wanted to add anything to that or pass it on to Senith from there.
I think the where we highlight the vulnerability in general is, Nishan, very much linked to poor visibility. So if there is greater visibility and transparency in the decision-making process as to, and so, like justification, because this is public money, when you're deciding to restrict and the objective, just like Iromi and others said, public purpose, right? So I think public, because this is public money, people have the right to know if the government decides to favor a certain group or favor a certain company and not go for competitive bidding, that it is done for justifiable reasons and that people get a better deal out of it. Unfortunately, in Sri Lanka, where visibility is lacking, information is lacking, and there is this, and we all know there is quite a bit of nepotism in the process. There is, especially in the national competitive bidding process, there is opportunity for politicians frequently use it to reward their supporters, and those kind of problems is what is risking erosion of value for money. Actually, if it is with proper visibility, I think I totally agree with Namal. There can be other reasons and good enough justifiable reasons to restrict bidding. But sadly, in Sri Lanka situation, Senith rightly said, poor visibility together with weak regulation is what makes it problematic. Thank you.
So Subhashini says there's a good theoretical reasons, but unfortunately, practically, quite abused potentially, and that creates a problem.
I completely agree with Subhashini. There is a problem in deciding on, there should be the step of analyzing and deciding what should be the mode, what should be the conditions for procurement, what should be done. And that discussion should be made public. And that is not there because that step is not taken as an analysis step by anybody. So completely agree. In deciding the mode of procurement, there should be a step that there should be consultation with the stakeholders and that should be transparent and made public.
Thank you. I'm going to ask a quick question on this, to anyone who wants to reply. What measures can be taken to improve? Subhashi talks about transparency and efficiency of the public procurement system. So, if we had to suggest incremental steps in the right direction, what would you suggest are the, 3 things that can be done to make this better, to make it more efficient, more transparent, and make it, help the value for money proposition take place? I'm going to keep it open for any of you who thinks that you want to jump in on that. Maybe Senith, maybe Subhashini, maybe anyone else, even who's joined this call. Yeah, go ahead. I think Chandra also had a list of stuff, and maybe you want to talk about that, Senith. Yeah.
Yes, so I'll start off with the question that you posed, Nishan. So if you are to take incremental steps, of course, other than increasing compliance and just making the actors behave better, one thing would be, of course, e-procurement. So Sri Lanka, anyway, even in comparison to the region, was a slow entrant to the e-procurement space. I think even as recent as 2017, Verité Research also did a report on why we should adopt e-procurement. But currently, there is an e-procurement platform that is in development, which is called Promise, initiated by the government from 2018 onwards. So if you are to start, if you are to take a next step to that, currently the Promise system, even though the vision and the mission is to completely encompass all procurement activities onto that platform, thereby creating an all-encompassing e-procurement platform. Currently, it's only limited to shopping and goods and services. I think mainly goods, the last time we checked with the officials there. So one step would be to extend the progress, actually fast track the progress of that e-procurement platform to include large infrastructure projects, because that is where there is going to be a lot of red tape, bureaucracy, information issues. So having e-procurement would be one of the biggest steps forward. And that's something that was actually included in the 2018-19 guidelines, as Subhashini pointed out, which were actually gazetted but not implemented. So e-procurement would be one. And the second would be to sort out the back end when it comes to information as well. Because right now, we do not, at least from a public point of view, when we did our research, we didn't see a proper information collection methodology and also standardization when it comes to procurement information. But another proposal, once again included in the procurement guidelines in 2019-18, is adopting this method called OCDS, Open Contracting Data Standard, where you collect and you compile process information, which can be then used to give access to public a set of information that is comparable, that is analyzable, and that is something that could be used just beyond reporting procurement information. So I would say, starting off with those 2 points, which are already included in the draft procurement guidelines, would be one step forward when it comes to transparency in general. And also just adding on to maybe what Jayaratna said regarding other weaknesses. So like even I think Namal pointed out correctly, so public participation directly in procurement is something that is crucial. That is something that has been incorporated in a lot of not only developed countries, but in developing countries. For example, in Philippines, there are independent observers when it comes to discussions on evaluating bids and deciding procurement methods. So that could also be another way forward for us, where we incorporate independent observers, members from the public, to observe how these decisions are made. And that's also something that will directly translate into increased transparency and answerability.
Super. So
මම හිතන්නේ ප්‍රියංකරටත් අත්දැකීම් තියෙනවා නේද? ප්‍රියංකර ඔබ්සර්වර් කෙනෙක් හැටියට procurement decisions වලදී participate කරන්න පුළුවන් වෙන එකේ තියෙන වටිනාකම ගැන මම හිතන්නේ ප්‍රියංකරටත් අපිට කියන්න දේවල් ඇති නේද?
මම හිතන්නේ ඇත්තටම මේ සුභාෂිනී කිව්වා වගේ මගේ ඇත්තටම මේ ජනතාවගේ ඒ සහභාගීත්වය තියෙනවා නම් කියන්නේ ජනතාවගේ සහභාගීත්වය අරගෙන ඇත්තටම ඒ අයත් එක්ක එකතු වෙලා ඇත්තටම අපි වැඩ කරනකොට බොහෝ වෙලාවල් වලට කුඩා කියන්නේ පහළ පණ්ඩමේ පහළම මට්ටමේ ඉන්න කණ්ඩායම් අපි පොඩි ග්‍රාමීය කමිටු විදියට හදාගෙන කියන්නේ ග්‍රාමීය කමිටු හදාගෙන ඒ කණ්ඩායම තුලින් ප්‍රාදේශීය මට්ටමේ කමිටුවක් හදාගෙන ඒ ප්‍රාදේශීය කමිටුව තුලින් ඒ ව්‍යාපෘතිය එහෙම නැත්නම් ඒ සංවර්ධන ව්‍යාපෘතිය සැලසුම් කිරීම කියන දක්වා ඇත්තටම යන ක්‍රියාවලින් සමහරක් තමයි අත්දැකීම් තියෙනවා. ඒක උදාහරණයක් ගත්තොත් පුත්තලම කියන්නේ කරුලගස්සව පුත්තලම මේ මාර්ගය සකස් කරද්දී ඇත්තටම සිවිල් සංවිධාන වලටත් අවස්ථාවක් දුන්නා. ඒකේ සහභාගී වෙලා රැකලා ඒකේ තීන්දුව ගන්න අවස්ථාවලට සහභාගී වෙන්න. ඒතර මම තමයි ඇත්තටම මේකට සහභාගී වුණේ. ඒකට එහෙම අවස්ථාවලදී අපිට හොඳ අවස්ථාවක් හම්බුණා මිනිස්සුත් එක්ක සාකච්ඡා කරලා ඒ ග්‍රාමීය කමිටු වල එක්ක කතා කරලා ඒ අයගේ උපදෙස් අරගෙන මේ එන්න තිබුණු ගැටලු බොහෝමයක් අවම කරගෙන ඒ යටිතල පහසුකම් ක්‍රියාවලිය පහසු කරන්න අවස්ථාවක් ලැබුණා. මම කියන්නේ ඇත්තටම මේක හොඳ අත්දැකීමක්. මම ඒකයි කියන්නේ හැමතිස්සෙම මේ ජනතාව මේට වඩා මුලින් ඉඳලම මේ ඕනම සංවර්ධන ව්‍යාපෘතියකදී මුලින් ඉඳලම මේ ජනතාව හවුල් කර ගැනීම එයාලගේ සහභාගීත්වය වැඩි කර ගැනීම තුලින් තමයි ඇත්තටම මේක දිනු කරන්න පුළුවන් කියන එක තමයි මම හැමතිස්සෙම දකින්නේ. ඒතර මේක කැඩෙන්නේ ඇත්තටම ගොඩක් කලාවට මේ දේශපාලන මැදිහත්වීම් ඕනටට වැඩි වුණා. ඒක අඩු වෙන තරමට ඇත්තටම අපිට මේක ගොඩනගා ගන්න අවස්ථාව උදා වෙනවා කියන එක තමයි මගේ අත්දැකීම මේ හැමතැනකම තියෙන්නේ.
ඔව් ඉතින් ප්‍රියංකර මේ ග්‍රාමීය සංවර්ධන කමිටු කියන දේවත් දැන් දේශපාලනීකරණයෙන් අයිත් වෙන් කරගන්න පුළුවන් ආයතනද? මොකද දැන් ග්‍රාමීය සංවර්ධන කමිටු වලට ගොඩක් ප්‍රොජෙක්ට්ස් යනවා හින්දා ඒක දේශපාලන ඒ කියන්නේ මම හිතන්නේ දේශපාලනීකරණය වෙලා තියෙනවානේ ගොඩක් රටේ මම දන්නේ මොකක්ද හිතන්නේ.
ඔව් දැන් මෙහෙමයි මම කියන්නේ ඇත්තටම මම යෝජනා කරන්නේ ඇත්තටම ග්‍රාමීය කමිටු කියලා කියද්දී දැන් අපේ ඕනම ප්‍රාදේශීය ලේකම් කොට්ටාසයක එක ග්‍රාම සේවක වසමක් උදාහරණයක් ගත්තොත් ඒ ග්‍රාම සේවක වසම තුල තියෙනවා ග්‍රාමීය කමිටු ගණනාවක්. විවිධ සිවිල් සංවිධාන අපි කියනවා CBOs තියෙනවා CSOs තියෙනවා. මම කියන්නේ මේ ඔක්කොමගෙම සෑදුන්ලත් ඒ කියන්නේ කෝ ටීම් එකක් ඇත්තටම හදාගන්න වෙනවා අපිට මුලින්ම මේ ඒ ග්‍රාම සේවක වසම තුල. ඒක ප්‍රාදේශීය ලේකම් කාර්යාලයන් තුල ඒ වගේ කෝ ටීම් එකක් හදාගන්න වෙනවා.
මම හිතන්නේ
කෝටීන්
ප්‍රියංකර
එක කියන්නේ
කතා කරන්නේ මේ දිස්ත්‍රික් සංවර්ධන කමිටු කියන රජයෙන් යන එක ගැන නෙවෙයි නේද? ඊට වෙනස්
නෑ.
එකක් ගැන. ඒ රජයෙන් යන ඒ කමිටු තමයි මම හිතන්නේ ගොඩක් දේශපාලනීකරණය වෙලා තියෙන්නේ.
ඔව්. මම
ඉතින් අපි
කියන්නේ ඒක නෙමෙයි
ඔව්
ඇත්තටම.
ඔව්
ඔව්.
ඔව්
මම
ඔව්
කියන්නේ ඒක
මම
නෙමෙයි. මොකද
ඔව් ඔව්
දැන් ඒ මට්ටම ඇත්තටම ගොඩනගන එක තමයි සිවිල් සංවිධාන වල ඇත්තටම වගකීම වෙන්නේ. එකක් අනිත් එක තමයි සිවිල් සංවිධානයට මේ ස්පේස් එක ඇති කරගන්න එක. ඒ කියන්නේ මේකට සඳහා වූ මේ කියන්නේ මේ කියන්නේ යාන්ත්‍රණයට මැදිහත් වෙන්න සිවිල් සංවිධානයට මීට වඩා අවස්ථාවක් තියෙන්න ඕන. ගොඩාක් වෙලාවට සිවිල් සංවිධාන වලින් බලාපොරොත්තු වෙන්නේ මේ ඉන්ෆ්‍රාස්ට්‍රක්චර්ස් වලට ෆන්ඩ් රේස් කරන එක විතරනේ. මම කියන්නේ ඒක නෙමෙයි වෙන්න ඕනේ. ඊට එහා ගිහිල්ලා මේ සිවිල් සංවිධාන ජනතාව මොබිලයිස් කරන කාණ්ඩායමේ කොටස්කරුවෝ බවටත් මේ තීන්දුව తీරන ගන්න වැඩසටහන ඒ කියන්නේ මුළු ක්‍රියාවලිය ඇතුළෙම සිවිල් සංවිධානයයි ජනතාව ඉන්න ඕන කියන එක තමයි මම හැමතිස්සෙම කියන්නේ. එහෙම වුණොත් තමයි අර එන බාධක අවම කරගන්න ලේසි. නැත්නම් අර ඔබතුමා කියන වගේ හරි. අර දේශපාලන ප්‍රාදේශීය දේශපාලනඥයෝ අල්ලගෙන ඉන්න 3-4 දෙනෙක්. ඒ 3-4 දෙනා හරහා තමයි ඔක්කොම මෙහෙවන්න හදන්නේ. අපි කියන්නේ ඒක කඩන්න ඕන. මම කියන්නේ ඒක තමයි තියෙන අභියෝගය. ඒක තමයි අද රටේ මූලිකම අවශ්‍යතාවය වෙලා තියෙන මේක පහළ මට්ටමින් මෙන්න මේක අපි වෙනස් කරන තැනට අපි ගෙනාවේ නැත්නම් මේ යන විදිහේදී ඇත්තටම අපි මොනවා කතා කරත් මේ සිස්ටම් චේන්ජ් එකක් අවශ්‍ය වෙලා තියෙන ඇත්තට මේ වෙලාවේ මේ චේන්ජ් එක තමයි අපිට අවශ්‍ය වෙලා තියෙන්නේ. මේ චේන්ජ් එක අවශ්‍ය වෙලා තියෙන වෙලාවේ සිවිල් සංවිධාන වලට අපිට පුරවැසියන්ව බලවත් කරන වැඩේ. මේ පුරවැසියන්ව ශක්තිමත් කරන වැඩේ අපිට ඇත්තටම කරන්න වෙලා තියෙනවා කළ යුතුව තිබෙනවා. ඒක කළොත් විතරයි ඇත්තටම මේක ජය ගන්න පුළුවන්.
thank you ප්‍රියංකර. මම ශ්‍රියානිගෙමුත් අහන්න කැමතියි. මම හිතන්නේ ශ්‍රියානි ගොඩක් බජට්ස් එහෙම ඇනලයිස් කරනවා. ඉවැලුවේෂන් කමිටිස් වල ඉන්නවා. මේ පිළිබඳ ශ්‍රියානිගේ අවබෝධය මොකද්ද? අනිත් එක තමයි මේ RTI කියන එක. දැන් RTI ගැන නීතියක් ආවා. ඒකෙන් ඇත්තටම දත්ත එලිදරව් කරන්න ආණ්ඩුව බැඳී ඉන්නවා යම් විදියකට. ඒකෙන් මෙතන වෙනසක් වෙනවද? වෙනසක් කරගන්න පුළුවන්ද? මොකද්ද අපි මෙතන දකින සම්බන්ධතාවය? ඒ කියන්නේ අපේ ගවර්නන්ස් ඉම්ප්‍රූව් කිරීමයි RTI එකයි අතරයි මේ ප්‍රශ්න අතරයි. ඔව්.
ඔව් අර ප්‍රියංකර කිව්වා වගේ ජනතාවගේ සහභාගීත්වය නැත්නම් සහභාගීත්ව ප්‍රවේශය අත්‍යවශ්‍යයි. ඒ වගේම තමයි සිවිල් සංවිධාන ඒ අතර එන්නකොට ජනතාවට ඒ ප්‍රවේශයට ඉතා පහසුයි. එතකොට මේක පවුරක් වගේ හැදෙනකොට අර ප්‍රාදේශීය දේශපාලනයට තේරුම් ගන්නවා ජනතාවට මේක අවබෝධයක් ලැබිලා තියෙනවා. උදාහරණයක් වශයෙන් පළාත් පාලන ආයතන බැලුවොත් ගොඩාක් බිම් මට්ටමේ තියෙන පාරවල් ප්‍රාදේශීය සභා යටතට යනවා. පළාත් පාලන ආයතනයට යනවා. ඊළඟට ගිහිල්ලා එක කොටසකදී පාර හැදෙන එක නවතිනවා. ප්‍රශ්න ඇහුවා මේ කාගේද කියලා. ඇයි මොකද මෙහෙම වුනේ කියලා. නෑ ඒක පළාත් සභාවටයි. අනේ ඒ වගේ බෙදීමක් තියෙනවා. ඊළඟට ජනතාව එතනින් එන මහා පුදුමාකාරක මේ උත්සාහයක යෙදිලා ඉන්නවා. ඒක නිසා අර ඉන්දියාවේ ජනාග්‍රහ වගේ සංවිධාන ගත්තාම ඒක කරන්න පුළුවන් තරම් ජනතාවගේ ප්‍රවේශය සක්‍රිය කරනවා. එතකොට ජනතාව තොරතුරු ඉල්ලා හිටනවා අර මේ අපේ ඔබේසකර වගේ ජනතාව පුළුවන් තරම් ප්‍රශ්න කරනවා. පාරක් හැදුවනම් පාරේ ක්වලිටි එක ඇස්තමේන්තුව දකින්න ඕන. අපේ රටේ ලොකු ප්‍රශ්නයක් තමයි සැලසුම් ඇස්තමේන්තු ලිවිං ඩොකියුමන්ට්ස් නෙමෙයි. ජනතාවගේ අතරේ නැහැ ඒවා. ඒක ජනතාව අතරට යනවා. ජනතාව එන්න ඕන. අපේ මේ ප්‍රියංකර කිව්වා වගේ. අනික තමයි මම දකිනවා පෞද්ගලිකවම නිශාන් තොරතුරු දැනගැනීමේ පනත RTI ඉතාම හොඳ උත්සාහයක්. හැබැයි ඔයා හිතනවද දැන් යම් පොදු ඉදිකිරීමක් අපි කියමු දැන් මේ ප්‍රතිනිවාසනයක් මේ රීසෙටල්මන්ට් ස්කීම් එක සමාජගත කරාම මට හිතෙනවා ඒකේ එක අතයි කියන්නේ අපිට RTI ගැත්තේ බලන්න සොයන්න. ඇයි දන්නවද ඒකෙන් අපි දකින්නේ විනිවිදභාවය විතරයිනේ. හැබැයි යම් දෙයක විනිවිදභාවය විතරක් කියන වෙනස් වෙන්නේ නැහැ. ඒක වගකීමක් හඳුනා ගන්න. කොච්චර දුරට මේ ආදාළ ක්‍රියාත්මක කිරීමේ ආයතන ඊළඟට මේ වගේ සොයා බලන ආයතන කොයිතරම් දුරට මේකට වද වෙනවද? විශේෂයෙන්ම ඊළඟට මේවා දුන්නාට පස්සේ post monitoring, post evaluation, ඊළඟට post reviews කොච්චර සිද්ධ වෙනවද? කොහොමද මේවා ඉස්සරට? ඒක නිසා අපේ රටේ අඩුවක් තමයි right to accountability act එක. නීතියක්. ඒක ලොකු අඩුවක්. අන්න මේ දෙක එකට තියෙනවා නම් සමබරව තියෙනවා නම් අපිට ජනතාවට තොරතුරු ගන්නවා වගේම ඒ තොරතුරු එහාට ගිහිලා බලන්න පුළුවන් කවුද මේකට වගවීම තියෙන්නේ. මේ ප්‍රශ්නේ අහන්න ඕන අපි කොහොමද? ඒ ප්‍රශ්නට උත්තර දෙන කවුද දෙපළයි මේ ටික අහගන්න පුළුවන්. ඒක නිසා මෙන්න මේ දෙකේ සම්බන්ධතාවයේ අඩුවක් මම දකිනවා.
බොහොම ස්තුතියි ශ්‍රයානි. ඒ කියන්නේ අර right to information කියන එකෙන් දත්ත ලබාගෙන ඒක වගවීමකට පෙරලන්න යම් ව්‍යාපාරයක් හෝ ක්‍රමවේදයක් අවශ්‍යයි කියන එක මම හිතන්නේ ඉතා වැදගත් අවබෝධයක්. Can I just move to Namal Ralpanava? And as I do, I just want to highlight for those who are not on this call what Mr. Chandrajaratna pointed out as ways to improve procurement. He said, or laws, so conflicts of interest and related party transactions, that there has to be a law or something to deal with that. Transfer pricing issues, money laundering, supply not conforming to set specifications. So that's, I think, what Sriani said is monitoring and evaluation. And lack of compulsory post audits. ඒකත් අර ශ්‍රියානිගේ monitoring evaluation එකට මම හිතන්නේ ගැලපෙනවා. ඒ ඔඩිට් ක්‍රමය කොහොමද කරන්න කියලා. දැන් සමහරක් ජාත්‍යන්තර ආයතන මට කියන්නේ දැන් monitoring and evaluation ඒගොල්ලන් අත්‍යවශ්‍යයි කියලා ලියුවට රාජ්‍ය කරන්නේ ඒක බාරගෙන කියනවා. හැබැයි ඒ කොන්ත්‍රාක්ටුව යන්න ඕනේ මේ ආයතනෙට කියලා. ඉතින් monitoring and evaluation කරන ආයතනය රජයට ලැබි ආයතනයක්. ඉතින් ඇත්තටම කරන monitoring එච්චර වැදගත්කමක් නැහැ. හැබැයි නීතිමය වශයෙන් අවශ්‍ය දේ කරලා තියෙනවා කියලා පේනවා. හරි ඉතින් මෙතන ලොකු ප්‍රශ්න ඇත්තටම රජයේ ක්‍රියාකාරීත්වය අවංක නැතිකොට මේ වගේ ප්‍රශ්න විසඳීම මම හිතන්නේ ඉතාමත් අමාරුයි. ඒකයි මම හිතන්නේ අර වගවීමට ලක් කරන්නේ කොහොමද කියන එක. ඉතාමත් වැදගත් කියලා මගේ හිතන්න පුළුවන්. Namal, over to you.
Thank you. The one point I want to bring out is that we are actually missing a huge step in a life cycle of a project, because all these things that we are talking about now about procurement, land acquisition, even EIA, all those things need to be looked at and studied right in advance in order to even decide whether the project should even exist. So I think we are always close to the fact that somebody could come up with a project, but it can be you can just decide not to do it. It's okay, right? So the issue is that even from the side of the public, most public, if RDA just comes and says, okay, we are going to build a highway from Colombo to Ratnapura, everybody is like, yeah, it's wonderful. But you cannot make this decision. Even RDA cannot make this decision that a road from Colombo to Ratnapura is a good thing for the country. So the EIA is done with the purpose of deciding even whether the impacts are mitigable. The RAP is done in order to first find out, in case such a project is done, can we do the acquisition? How much acquisition is needed? Are people okay in case the project is done? The procurement decisions we just talked about just before in deciding where should the funds come from, where could we get the funds, what kind of procurement is good for this project. All these things have to be looked at in advance, and only after looking at that you can calculate even your EIRR, and only based on that you should even decide whether the project should be done. Now, a lot of the problems we are facing now is because we do the EIA only after the project is, you have told the people and everybody is waiting for this project to happen, then you do the EIA, and actually then the CEA loses its position or leverage to say, no, it is not okay. Same thing with the RAP, same thing with the procurement, right? So if this and this whole transparency, stakeholder consultation, all those things should be done before the project, so that if the people disagree, if you actually find impacts that cannot be mitigable, if you find that it is going to be too expensive, that at this point you cannot do it, then there should be the opening to simply say, no, we are not going to do it, because we are better off without the project than with project. And we do not have any kind of regulation or any kind of guideline in this country to give the steps. What should be the life cycle or the steps of a project? What should be done right now when cabinet approves projects? Nobody even knows anything. Like nobody knows any impact, and even the costs are calculated. Now, if you don't do a RAP, you do not know the cost of the land acquisition, right? So then EIRRs are calculated without considering the cost of land acquisition, without knowing. So although I think Sriani and Subhashini, Priyankara, everybody said if when people know that the acquisition is for a development cost, people do not disagree. I think that is wrong. We should educate people to disagree if it's a bad project. If it's a project that is actually useless, if it's a project, because this is again people's money anyway, right? So,
Thank you, Nabat.
so this is the point.
Thank you so much. I'm going to try to bring us to a close because we promised to finish at 5. Is Uween's camera being on suggests that he wants to say something, in which case I will let you say something. You're still muted. And then I'm going to ask Iromi to maybe have a last word. Subhashini to then kind of wrap up in the best way she knows to, and then I'll do the final wrap up. We're still going to go on for another 7 minutes, I think, by having 3 people contribute. But let me start with you. Yeah.
No, Nishan, I actually switched on my camera because I had lost power and I just got back on.
Okay.
So I'm
we
fine.
asked you so many questions, Uween. I'm sorry you missed them. I'm just telling you.
I'm so sorry.
Yeah, Iromi, do you want to maybe comment on what we've been talking about and add your final thoughts? I think I won't come back to the other panelists now because we've had them come back, and then maybe Subhashini can add her thoughts, and I want to say some final words to close. So just to let all of you on the call know that we think in the next 7 minutes we should be able to come to a close. Yes.
Thanks, Nishan. I think two quick points. One is I completely agree with what Namal said. We should be opposing development projects where don't work for us. And I think Port City in particular comes to mind. Big infrastructure projects in Colombo around condominiums and malls come to mind as well. I think the issue though is that by the time that people find out about the project, so much has already happened. And I think again, Port City is a perfect example where by the time, the wheels had been moving for a long time, agreements been signed, and there's also with that huge lack of information, you can't make an informed decision when all that information is not available to you. And even to build up any kind of opposition, it's too late. So that's one point I want to make, and that's why information disclosure and consultations are so important from the start. And by consultations, I also don't mean some chap from the government coming and showing a PowerPoint presentation to people. That is just a very one-way of doing consultations in Sri Lanka. Here we should be, like in many parts of the world, making these documents public, not just in English, but in Sinhala and Tamil, having a long period open for comments, and as well as outreach, where through radio, TV, newspapers, say, there is this project, we have made all of it available, go to your DS office, you can read it, download it if you want to. So, make it available in every possible way for people to meaningfully engage, and then we can decide whether we need this project or not. And I think the other quick point I want to make is that when we are working on projects that are funded by banks, World Bank, AIIB, ADB, we are bound to, as everyone has been pointing out, we are bound to follow their frameworks, whether it's their ESF or their safeguard statements or procurement standards or whatever. And they are at a much higher level than what is available for us locally. But what we do see is that even at a higher standard, through the capacity building that is built in by the banks, our state agencies are very, very capable of doing it. I've seen excellent reps that are done by the UDA, by the RDA, and these are the same people who turn around and say for a project that doesn't require all of this, Hussein eka karana velawak nahe, eka karana kattiya nahe, eka karana salli nahe. But when they are bound to do it, they're actually quite able to put together a really good document. So I think we need to try to bridge this situation where, why do you do it only when you have to do it, or when you're obliged to do it? So I think those are just the two comments I want to make.
Thank you so much, Iromi, and thanks for joining us. Subhashini?
Yeah, I'm sure you will thank everyone. So I just wanted to say that this was a very, very interesting discussion. And I think we have a lot of problems that needs to be solved. Obviously, you have worked on this area maybe longer than us. And nothing happens within very short periods. Like Iromi said, but we should not give up. We should keep on talking about these things and creating more awareness and creating greater demand for better reforms and better regulations, so we have better outcomes on the development projects that actually deliver development for everyone. So I think I would like to also say we are going to have for the audience, we are going to have a similar very interesting session tomorrow on environment impact assessments. And I think the public has raised a lot of concerns about environment and impact on environment, to what extent environment considerations have been incorporated into the decisions of infrastructure investment. So I'm sure the audience will find it very interesting and insightful, the session we are going to have tomorrow from 2 to 5. So I would really like to invite all of you to join. And please also go and read the documents on our website. It has a lot more information than what we've discussed. I think Uween and Senith only touched on very few issues and few gaps we've identified. We have given much more broader overview of the publications. And please read and also give comments. I think Namal, when we shared, gave a very, very useful comments, and we really appreciate people taking the time to thoroughly read it and show us where we have gotten some things wrong. That is most welcome. So please go and refer these documents, and I will hand over to you, Nishan, for the concluding remarks.
Yeah, so thank you for everybody here. I'll begin by, before I summarize, just thanking the panelists, right? So I think Priyankara, Sriani, Iromi, who joined us and brought a wealth of insight from experience. I think, and one of the things I thought we learned enormously through the conversation is the connection that people made from compliance and information to say that in Uween's thing, the underdeveloped processes, the unreasonable ways people were treated, the unfair compensation, all this related not only to the problem of information, but also to actually poor accountability of the system, and that poor accountability allowed poor analysis, which ultimately led to bad outcomes. Right. So that is the connection we are making. This is not just about good governance because that's good. It is because it results in terrible outcomes for society and for the country and the future of the country. And the kind of debt problems we are in, the fiscal problems we are in, are a sign of how not attending to these things that we kind of like to park away as good governance are resulting in really bad outcomes for us as we move forward as a country. And so accountability and analysis, I think, are the two A's that came out very strongly as connecting to what was put forward today, if we are to avoid bad outcomes. So thank you for all your contributions.
I have a humble request.
Yes.
Humble request, very short. Yes. With all your efforts, please try to turn involuntary resettlements to participatory resettlement.
Right. Yeah. So a policy of participatory resettlement. Thank you, Sriani. And thank you, everyone, for your patience and being here. We've run 10 minutes over time. We look forward to seeing you tomorrow at the same time at 2 p.m.